Welcome to Baker's channel where stories unfold, covering trials, dramas untold. Grab your seat, settle in, start the show. Courtroom clashes, the fun we bestow. Baker's channel, action's hot, dramas and fun, all we got. Discuss, debate, break it down. Baker's channel, just the best in town. Lawyers spar, tensions high, sparks fly. We laugh, we learn, dive into the why. Join the chat, have your say, it's your place too. Every twist, we're here for you. Baker's channel, action's hot, draws and fun, all we got. Discuss, debate, break it down. Baker's channel, just the best in town. Join the crowd. Baker's channel, we're live and loud.
Good morning, good evening, good afternoon, wherever you are, whoever you are, what if any you are, and welcome, Mo, to finally the not the Karen. I have Karen Reed on my mind. The Sarah Boone hearing.
Yes, we have it. And not just the tip today, the whole thing.
Yeah, we will grift the whole thing today. Clickbait and all. And before we start, for Fox's sake, became a YouTube member. Thank you. It's funny how Fox in English is close to a bad word, and Danish, a fox is called a rev. That's how you say the part of your body you sit on in the rural parts of Denmark. So it also have a double meaning in Denmark.
The more we're different, the more we're the same.
We are common folks divided by a language and a big effing ocean.
True.
But that doesn't mean we don't like a double entendre.
Or a single entendre, if you're me.
Well, that's the good weekends turns into a trois entendre. You have to pay extra, but you get to disappoint two women at once.
Well, you know, I have a bucket list goal now.
Why do we do that? Did I wake up in a handbag this morning? No. I wouldn't go into... I would have to be... if you have to ship me with a plane, I would have to be in those oversized bags, like your skis or your golf bag. I couldn't fit in any Samsonite products you can buy and carry on a plane. Loving the hair, Mo.
Thank you so much. Every so often it gives me a good hair day, and I just rejoice in those and put on wigs every other day.
Sorry. We will respect the carry-on luggage on this channel.
Yeah.
That's fat-shaming, Toila Carissa. That's not okay. None of your business. Yeah, that 911 call is weird. We listened to that a couple of weeks ago, I think.
Yeah, there is no way in hell she was doing CPR. And then the question she was asking, just weird.
Hey, Venus. Mo, can you raise your arms?
Not really. I am actually shocked. I got this punching thing that you put on the wall, and it looks like one of those old school Simon games, which I was terrible with, but now I get to punch them. So I did 15 minutes of it, and my arms are sad, but my trauma from never winning at Simon is feeling better.
the Visa commercial with Simone Biles and a huge suitcase, but she's small. Yeah, those. I've been watching a little bit of the Olympics because I went to my massage today, and she did me over. As she said, "Oh, now you're loose and limber," and I didn't even have to pay extra. That was a smack show. So I went and watched people crawl up a wall. Jesus, those rock climbers. There was one girl. It didn't seem like there was anything to grab onto. She just had her hand flat on something, and she was just hanging in her arms. I can't do a wall hang. I'm too fat for that. And they're just swinging about, and I think it's fatphobic to put on the Olympics. I will have it banned because there's no plus size people. Oh, there's a Danish plus size girl throwing discus or something tonight. Finally, I will feel represented.
I don't know. I kind of got lost in the 12-year-old giggle fest of the vault or the pole vaulter who got unmanned by his manness.
Well, it's
Wouldn't you secure that though? I mean, if you're in an aerodynamic sport, wouldn't you? I don't have that on lockdown.
I know people. Well, his knees touched the bar first. No, I would be running to Twitter and everything and said, "Nope, my knees never touched that bar." And
No.
ladies, these are my digits. The female Danish hurdler is stunning. I haven't seen her. I saw one who hurt her hamstring. Maybe that was her. We have some beautiful women too.
I was watching the synchronized dance swimming, and that was pretty cool.
Yeah, I saw the swimmers yesterday. That was it's a weird. Let's not fool anyone. It's weirdos. That
Well, who wants to put their legs in the air and look like a wash machine agitator? But it's a sport, and if I could do it, I would totally do it.
yeah, of course, but they have to do some dynamic out of the water move, and the Americans jumped in and just threw a lady out of the water. And I just sat there and think, I played on the lowest level you can play organized football, real football, not handy.
Ah,
And I was at such a low level that the guy who got to be captain for the match was the guy who had the worst hangover. If you were still drunk arriving to the game, you were automatic shoe in as captain. So let's just say I'm not a very athletic guy. I'm built like I should be dragging a plow.
You're like me. We're more Clydesdale than we are, dressage pony. We're in the work division of the show pony, state.
And I get amazed what people can do with their bodies.
Yep.
I'm not going to spoil the coverage today. Please don't either. Tim Swoop, we will get started immediately because this is a case of the biggest injustice in the land. This poor lady who is a straight A student who did say the magic word, not intentionally. He's being forced to be a pro se indigent litigant against her will. And this is the first hearing. I listened to a bit of it because it was released at around 11 my time yesterday. So I was going to bed because I had the wonderful Brandy Churchwell and the just as wonderful master grifter, Mark Betterow, on. It's a joke with Mark grifting because he's the nicest person in the world who never ever even says, well, can you shill my Twitter or anything? He just comes on and talks for 2 hours and is amazing. But we have that little joke because I didn't make the grift list. But I didn't really want to do a Sarah Boone show after that. I needed a bit of sleep. Hello, Sherna.
Yeah.
But let's get to it. and do it.
Her hair still doesn't move. God bless hairspray and/or gel.
And Crash Daddy's Canning ask, who say they're a straight A student at 40-something years old? She's 47 years old. No, she's 46 years old because she's 10 months younger than me, and I'm 27. And she peaked in high school, probably not even high school, middle school. So she remembered those days fondly.
I'm going to need to see a picture of her high school yearbook. I want to see how big that hair was in the 70s. What do you bet she had a perm? Photoshop? I'm just saying, if anyone's really good at that, I need Sarah from the early 70s.
Well, do you think she had that swoosh that was really it was really hot back in 89, 90?
I think she had the whole. So you've seen Working Girl with Melanie Griffith. I think she had like the Joan Cusack full bang and then teased to to death, and neon eyeshadow. No, very thin eyebrows. I'm going full 80s.
Thank you, Marissa. He was on asking last week. I missed something. No, but I just remember that we thought girls were really hot if they had that where the bangs were up in a swoosh. Oh my God. And the more erect you can get it. Ooh.
I never quite understood that, but I'm glad it floated someone's boat.
Yeah, it's... I don't know. All by myself, don't wanna be all by myself anymore. Jesus, you're old,
Well,
Tim.
Yeah, she could not have a more insufferable face. Like, just, she looks irritated already.
Yeah, she has that chronic. Nope, I don't speak to middle management. I need management. Look,
Not your manager, the district manager.
look, Carrie's a baby. I have Dex in my fridge that's older than her. Probably throw those out.
Oh, is she going to talk about a day in her slides? Because I'm here for it.
Oh, she got a nubby. No, it's a full
She
size
got a
pen.
real pen. She's going to steal that.
She's gonna snap some.
She's going to use that to make a mean letter to the hurricane for delaying her.
True love is not nice. I don't know. I never experienced true love. I
Oh,
only
Baker.
experienced that nasty, dirty love.
Well, that's apropos because I think she only experienced that too.
Yeah. Do you think them making art was a euphemism for them being on the plastic sheet with body paint?
God, I hope not, because I have a very active imagination and that just popped into my head, so I need to go bleach my brain.
Thank you. She is 47.
Can you please state your full name and date of birth for the record for me?
Sarah Boone, 10/10/77.
I do see that we have a representative from JACS that's appearing virtually. Sir, can I get you a appearance for the record as well?
Yes, Your Honor. Christian Lake with the Justice Administrative Commission.
Okay, very good. All right, we've got a couple of things that we're going to be addressing this morning. The first is the motions, Ms. Boone, that you had made reference the last time I saw you. The court has reviewed all of those motions. I've reviewed also JACS's reply, specifically their response to the motion seeking due process costs that was filed on July 30, 2024. State, have you had the opportunity to review all of Ms. Boone's motions?
Yes, Your Honor.
Okay, all right. Ma'am, I want to go through each one of them and hear from the state, from yourself, and from JACS. We're going to start first with y'all can be seated, you don't need to stand, thank you. The defendant's temporary motion for reservation of proposed costs to acquire investigator for defendant's defense and trial dated July 18, 2024, received July 29th. That request seeks to reserve any and all costs proposed to be incurred to acquire investigator. The defendant's temporary motion for reservation of proposed costs to acquire all witnesses for defendant's defense and trial dated July 18, 24, received July 29th, 2024. The request is to reserve any and all costs proposed to be incurred to acquire all witnesses for trial. And then defendant's temporary motion for depositions to be conducted per FRCP Rule 3.220 by defendant under pro se attorney title and position ordered by the judge in court dated July 18, 2024 and received July 29, 2024. I have reviewed all of those motions. All three motions reflect to be determined or TBD with regard to the investigator, witnesses, and deponents. The total amounts are to be determined. How to calculate is unknown. As for the depositions, the date are to be determined, and the amount of transcripts are unknown. Mr. Lake, I've reviewed your response. Do you have anything else to add, sir, with regard to those items, investigators, witnesses, or deponents?
Not really, Your Honor. The only thing is we can provide Ms. Boone a copy of our pro se packet that has information about, including model motions. We would have to send her a copy or to send your JA a copy that you could send to give to her. That might help her for purposes of future motions. But as far as these are concerned, I think our response pretty much outlines what our position was to each of those requests.
Okay, thank you, sir. If you would be so kind to send that to Ms. Barrios, we will ensure that Ms. Boone gets a copy of it. State, do you have any position with regard to those three motions that the court just identified?
No, Your Honor.
Okay. All right, ma'am. So previously, Prison Break Investigations was already appointed to be your investigator. The JAC has no objection to authorizing $5,000 in costs for Prison Break and for $500 for obtaining case-related documents and materials on your behalf. So seeing as there's no objection, even though you were asking for a reservation, I'm going to go ahead and permit that cost to be incurred. With regard to the costs for witnesses and the depositions,
I don't know why, but oh my.
Giggity, giggity, giggity.
Yeah, I love that it's Prison Break Investigations that handles her case. Was it 5,000 or 500?
I thought it was 10,000.
Well, then 10,000 2 times 5.
Okay, yeah.
Marissa, don't spoil anything. We haven't watched it.
you are requesting, as I identified earlier, just to reserve those costs. And as I had said earlier, the motions do not identify who the witnesses are or what the deponents are. So I'm going to deny those motions with prejudice, but that means you can refile them and we can readdress them when you file motions in the future addressing any of those items for ensuring witnesses being subpoenaed or appearing for your defense at trial, or for any persons that you may seek to depose. Because as of right now, I don't know who it is that you were seeking to depose based on your own motions. Do you understand the court's ruling as to those three motions, and do you have any questions, or do you want to add anything?
I would like to add, please.
Sure.
With your delegated due date of July 22nd, for all of my pretrial motions to be submitted, I have yet to receive my discovery, so I was trying to beat that deadline or at least meet it. So I don't know what I'm supposed to ask for or who I'm supposed to ask for, and again, I have yet to receive my discovery, so I don't even know who it is I need. So I understand for those, so you're telling me at a later date once I have that information to revise them.
I'm giving you the opportunity to refile them. Yes, ma'am.
Thank you.
Because you can't treat anyone different. So the businesses who might attack you because she needs to be in handcuffs, the Sarah Boones who will just bore you to death also needs to be in handcuffs, or else you would have different treatment under the law, which would be discrimination. So that's why. But at least she's not in leg irons.
I do wonder why she wasn't given the packet with the order that said, you are now pro se.
Yeah. Yeah, that should be. And again, because it's court ordered, if she had chosen to become pro se on her own relation, I could understand it. But he told her, you be pro se now. They should just do that. Yeah. This is a good question. Why isn't she allowed to sit at the defense table?
It might be the court setup. I don't know.
Yeah, flight risk, something like that, maybe. This is a person not to ask, do you want to add anything? Exactly. She has standing whatever face. Yeah. This is the lady who will yell at a Starbucks barista for spelling her name without the H.
Yes.
Well, Chelsea, that's... Yeah. Well, I don't see her dragging any luggage along, so the likelihood of her sipping him into something, maybe not that big. Maybe she'll... I bet you she stuffed a lot of people into lockers in school. That's where it started.
Yeah.
She got her kink back then.
It's a pattern.
Oh, she did attack a previous lawyer. I didn't know that. Well, thank you, Wolfram. I didn't know she had attacked. I just heard her. She yelled a lot about them. Hey, Fubar. Good morning. Yeah, only admitting to the crime 20 million times probably won't work in her defense. I don't know.
Yeah, if only she had remembered to, delete that video from her phone.
Yeah. Yeah. If you look, she's working on one piece of yellow paper. Couldn't they afford to give her a couple of these? Well, she used the rest of it to make her ads for lawyers.
Probably.
With regard to the defendant's motion for reservation of proposed costs to With regard to defendant's motion for reservation of proposed costs to acquire expert witnesses for the defendant's defense and trial dated July 18th, 2024 and received July 29th, 2024.
BL, both of them had a history of DV.
For Mr. Lake, anything else to add other than what is identified in your response?
No, Your Honor. Again, the issue here is with the exception of the mental health expert that's already been approved, there would need to be much more specific motions for these costs. Ms. Boone needs to include essentially what we included in our response. And again, the model motions that we will be sending to will have that information. Without specific information, neither us nor the court can make an informed decision on whether the requests are appropriate.
Okay. Ma'am, the motion fails to identify any specifics. It has to be determined for your expert witness or witnesses. It does not identify the type of the witnesses. It doesn't identify the amounts, and it's difficult for me to identify the particular showing of need, which is what's required for the appointment of that expert. So again, I'm going to give you the opportunity to refile in the future a motion pertaining to any specific experts, identifying the specificity that JACS has requested in their response. So at this point in time, that motion is denied without prejudice, and you'll have the opportunity to refile it. Lastly is the defendant's motion requesting immediate relief to the defendant by appointing effective standby counsel to aid in support and preparation of a criminal case for trial dated July 18, 2024 and received July 29, 2024 the request, ma'am, that you were seeking in that motion is to provide immediate relief to defendant by appointing effective standby counsel to aid and support in preparation of her criminal case for trial. State, do you have any position with regard to Ms. Boone's request for standby counsel?
No, Your Honor, other than what's already been placed on the record in the court's order.
Okay. Mr. Lake, anything over and above what's in your response?
Just briefly, Your Honor, the point we would make, Your Honor, is I think Ms. Boone misunderstands the role of standby counsel. Standby counsel is not co-counsel or assistant counsel to a defendant. Standby counsel is there for when, in the situation where a pro se defendant who is elected to represent herself decide at some point they want a lawyer, that allows the court to put a lawyer back into play at that point in time. In other words, it's a safety mechanism so that if a defendant who has decided to represent themselves decides at some point they do no longer want to represent themselves, the court has a lawyer already in place so that the progress is not delayed. It is not an assistant or a co-counsel. It is someone whose role is consenting not to get involved until the defendant says, I no longer want to represent myself.
Ma'am, the court's had the opportunity to review the case law on this issue. There is no constitutional right to standby counsel as decided by Paul versus State, 152 Southern 3rd, 635 at pinpoint 641 by the Florida 4th District Court of Appeal in 2014, citing to the Florida Supreme Court case in Jones v. State, 449 Southern 2nd, 253 at pinpoint 258 from 1984. As the court has determined that you have forfeited and alternatively waived by your...
I think he's from the Public Defender's Office, the guy on the screen, Christy G. I didn't hear it in the beginning because I was annoyed by his lisp.
Yeah, I hope he's not the lead attorney. I feel bad about that because I
think he's public defender. I think it's a public defender's office.
Oh, good. I was like, is this the state's attorney? Because this case is going to go even crazier.
Yeah, no. He because we heard from the state's attorney. He said, no, nothing. We've written our stuff.
Conduct the right to court appointed counsel. The court is not required to appoint standby counsel. That's Brown v. State, 45 Southern 3rd, 110 at pinpoint 114 through 115, Florida 1st DCA 2010, citing to, again, Jones v. State by the Florida Supreme Court in 1984. There is no Sixth Amendment right to simultaneously proceeding pro se and with legal representation by the Florida Supreme Court in 2009 in Shepard versus State, 17 Southern 3rd, 275 at 279. For the reasons that the court identified in its 16-page order previously entered, your request for standby counsel is denied.
Come on.
Do you have any other questions, ma'am, as to the court's rulings this morning?
First off, I do not forfeit my rights. That was your judgment. And also, I feel that I should have had some type of evidentiary hearing prior to your decision. So I could have better explained myself and you could have had a better understanding. So by you denying my standby counsel, which thank you to him for explaining to me what specifically it is, I don't want to be pro se any longer. So I didn't want to be pro se in the first place. And again, you, in my opinion, unlawfully denied me or didn't even suggest an evidentiary hearing in order for me to avoid or try to go about a solution or remedy so you would understand. So I don't know if it's me either wasting your time or anybody else's time, if it's even an opportunity or if it's just something that is denied, period.
It is denied, period. With regard to an evidentiary hearing, that seems to be in the realm of a Ferretta inquiry where a criminal defendant is seeking to represent themselves. And I would inquire of that person.
No, actually, Sarah fired 0 attorneys. 4 of them conflicted out because I believe 2 of them had been his attorneys in DV cases, or have represented him earlier. The last
Yeah.
4 is the ones that she has all the latest one, the female who was expressively found to take Sarah's case because she was used to working with difficult people. She told at her hearing where that hearing where Sarah said, "Can you tell her to be nice to me?" That when
Oh,
Sarah
yeah.
doesn't get what Sarah wants, she just stands up, walks out the room.
Yeah, and again, what the lawyers are dealing with is Sarah is never going to come off of this mindset that unintentional means not guilty.
Yeah.
So you can talk to her about what her real chances are, what we need to focus on. And if you don't say unintentional means not guilty, then she doesn't hear it. And I would believe that her first attorney was a paid attorney, and I believe she did fire him though, or the ex-husband paid a retainer, and he wasn't
Yeah.
doing what she wanted.
Yeah.
But there have been some conflicts of interest. So it's not just been Sarah like, "You're fired." It's
Yeah, and the judge goes into that in the motion where he makes a pro se by saying we don't have the Sixth Amendment doesn't give you the right to withhold justice by just being obnoxious enough to make your lawyers go away. And yes, audio is really bad. Shizzy is working on upgrading the audio. He'll send me a link. So hopefully, because when I can hear the clickety clack of a keyboard more than I can hear her, they should. Why don't they have a mic near her? It's such a stupid thing.
yeah.
She is quite talented with paint by numbers, and she likes to do puzzle.
She is. She's a craftologist.
Yes, and I'm here for every little bit of it. Mo will bring the popcorn. I will bring the pop or sodas, whatever you call it, in the part of the U.S. where you live, and we will have a party every day.
Yes.
A party in the USA.
I'm going to have to stock up on my Dr. Pepper, my Diet Dr. Pepper.
I have 3 cases of Dr. Pepper coming my way. My brother
You
went to
are
Germany.
set.
1 diet, 1 cherry, 1 regular.
Ooh.
So, well, bye, Mo. That was that Dr. Pepper envy. She couldn't stand that one. She won't ever understand. She is the victim, and she thinks it's being victimized by the system now. Yeah, she'll find a new victimology to live by.
Hit the wrong button. I pulled a
Never touch button. She's now trying to fire herself. Yeah, I don't want to be pro se. Oh, you did bring the popcorn. Well, good. I don't like tequila.
Person and have an evidentiary hearing as to the rights and remedies that you were forfeiting and the pros and cons of proceeding representing yourself and the benefits of being represented by counsel. Due to the Florida case law that was provided in the 16-page order, no such evidentiary hearing is required.
My understanding was the hearing, the Ferretta hearing, is regards to competency as opposed to having understanding before you take someone's right away.
Ferretta pertains to a criminal defendants seeking to represent themselves. Ferretta was not applicable to your situation, and that's identified in the case law citations that were provided in the 16-page order.
Yes, I understand. It was the day of that I was explaining most of all of this, and as opposed to prior, so I would know what happened or could happen. So my understanding is one thing, and then the explanation is another. So I'm just confused and feel that I should have had an opportunity prior to all of this to explain myself and to have a better understanding. So now my belief was that the evidence or the Ferretta hearing was simply competency. So evidentiary hearing I thought would be a collaboration of the information of why I wrote my letters in order for you to remove my rights to counsel. In my opinion, I felt that it was a type of retaliation by the court because you did not understand or attempt to understand any of my letters that I wrote previously, which was for the intervention of the judge and or the court to avoid any of this with me sitting in front of you present.
Ma'am, as identified.
So what she just said was, Judge, you're too stupid to understand me, so you got revenge on me by making me pro se.
Yeah, no, there was nothing vindictive. Again, he can't be vindictive. He's not supposed to. His job is to look at the laws and to make the final referee. He could have punted it and said, you have one more chance, but he told her as soon as this case went into his court, we're not doing shenanigans.
Yeah.
So
no, she's not complaining he didn't respond to the letters. She's complaining that she was actually trying to avoid this. If he had just understood what she wrote to him and told the lawyers to be nice to her, then they wouldn't have these problems. So it's on the judge. It's she's misunderstood.
Identified in my 16-page order. I listened to every audio hearing. I specifically provided dates and times and words that were specifically said at particular hearings involving yourself and prior counsel. I also made reference in the 16-page order to statements that were made in your letters. I promised you, I've read everything in the court file. I've read every single letter, and I've listened to every single audio. That decision was not made lightly, and it took a lot of time to make that determination and that decision, which explains why it was also a 16-page order. That order stands, it remains. The court's not going to revise its findings or its determination as to your forfeiture, and alternatively a waiver by virtue of the conduct.
Hazley Eyes, Moat sometimes type, but sometimes you will hear when she speaks, the typing you'll hear is in the courtroom. So, Mo, could you please?
And I will do better at muting when I'm typing.
Don't answer chat. It's just listen.
Identified in that order.
Okay. I believe, in my opinion, the order is erroneous, and after I reviewed your 16-page order, there are quite a few incorrect entries, and some of them are based on perjury by the attorneys. And by you reading and then also listening to the audio, you did not listen to me in any way, shape, or form in order for me to explain myself better, so you have an exact understanding of the particulars of each letter for each attorney.
I'm not going to revisit my prior decision.
I understand. I'm just trying to make you aware that it's my opinion.
You would, and like we talked about last time, ma'am, you're certainly entitled to that opinion. All right. My judicial assistant has been in contact with the representative from the Orange County Jail, Sergeant Donald Casey, who is on his way in order to facilitate the transfer of the USB drives from Prison Break Investigations. I do see that Mr. Lane is present. So as soon as he gets here, we'll be able to address that exchange. What we can do while we're waiting for that representative to appear is address some of the things that were identified in the notice of hearing for today, which is kind of a scheduling conference for when we might be setting up certain deadlines. As of right now, the trial is scheduled for October 7th. The trial will be extended from 2 weeks to 3 weeks. So the trial will take place on October 7th, October 14th, and the third week of October 21st. October 21st is not this division's normal trial week. However, the court has obtained coverage for that week so that should this trial proceed into a third week, we will not have to scramble.
Why 3 weeks?
Yeah, this doesn't seem like a case of whodunit, or this feels like we are going to get another 2.5 weeks of there was no snow.
Yeah, because again, opening statement, Your Honor, she did it. She admitted to do it. Let me show you this video of her admitting doing it. Let me show you the video of her laughing at the guy in the suitcase. Let me show you the autopsy photos. We rest our case, Your Honor.
Well, I do wonder, what is it that Sarah is now actively calling lawyers that are officers of the court, saying that they perjured themselves and or there were inaccuracies. Does she actually understand exactly how serious and egregious those charges are? I mean, if a court, officer was found to be directly lying to the court, they could lose their bar, license. What is it that she's claiming that was lied about, and why doesn't she have receipts?
Well, it's the statements that the lawyers made in their motions to uh, to leave her because she didn't do all the stuff they claim she did. So, random irrelevant question: have we ever seen Sarah cry? No, I've seen her straddle a bush, but I've never seen her cry. Because she gets mad whenever anyone says something to her and says, "But you're lying." She just starts yelling and then go back. She's really, if you watch the entire, I watched the interrogation like 3 times, and every time they push her, she goes back to Jorge's family, her ex-husband, or um, she constantly just deflects whenever they get into the meat and bones of the
Yeah.
case.
And she assumes they're just, coming up out of the ether with these assumptions. They're like, no, it's not assumptions. It's following evidence and putting together this, uh, dot to dot that Stevie Wonder could figure out. I
Yeah,
mean, it's not a whodunit.
yeah. She almost cried when she didn't get her Dr. Pepper. That's the closest. But I'm so thirsty. No, you had cotton mouth because you had been slamming cigarettes and wine yesterday. You seen her cry, Wolf. Good one.
In order to find coverage, and that we'll be able to efficiently proceed with any evidence or testimony on that third week on October 21. Pre-trial was scheduled for September 24th at 1:30. The court typically has its regular trial case managements on that Tuesday. Due to Ms. Boone representing herself and some of the complex issues that may be involved in this case, I'm inclined to change the date of the pretrial so that we might be able to have our own pretrial separate and apart from all the other cases that may be set for that same trial period. My thought would be to move it to, rather than the Tuesday the 24th, to Tuesday the 26th.
I don't know if you saw this from Ada. I think me and the deep end is Mo in the deep end, but you want the Tumblr? Reach out.
Okay. Awesome. I will do that. I was trying to look up a quiet keyboard on the slide.
I'm just saying you will have a feral Jamie outside your window trying to steal that Tumblr.
That is so awesome. Yeah, I will definitely get a hold of her because she is so great and she's got a cool setup too. And I love that she's making it more accessible with better captions. As much as I love the, closed caption shenanigans, I'm glad that there's a more accurate for those of us or those that maybe have a hard time hearing.
See you, Russian. I had one guy. Yeah, you weren't here when that guy said, "Could you please stop pausing?" I said, "No, because we're talking, so you don't miss anything." Yeah, don't you want more subs? I'll be fine. But Farrell, not Farrell. Jamie will fight you over that Tumblr. She has an addiction. I'm just saying.
At 9 a.m.
Is that a Thursday?
Yes, sir. That's Thursday.
that's acceptable to the state.
Ms. Boone, that would give you additional opportunity to prepare for trial as well. Are you amenable to changing that date to September 26th at 9 a.m.?
So an additional 2 days?
Correct. You would still have that time to prepare regardless if we had the hearing on September 24 or September 26th. I'm just moving it so that we don't have 50 or 60 other cases and I can focus more attention on your case specifically.
Of course.
She ought to
All
like
right,
that.
so pretrial will be rescheduled till September 26th at 9 a.m. One of the issues that I wanted to address was deadlines for production of the state's exhibits and the defendant's exhibits. Now, I'm mindful, Ms. Boone, that you have not reviewed some of the documents that may have been provided. I know most recently, Ms. Cashman spent 20 hours with you alone going over questions.
I think you can get mechanical keyboards with like a silicon under thing in the thing, so it doesn't make as much noise. Because it's I shouldn't hit
Well, it's
buttons.
bad when you want not clickety clackety, but you still want it to light up and have glitter and such. They just don't seem to sell for me. And thank you, Wolfram, for gifting 5 memberships. Those went to Publicly Buzzed, Participation Trophy Wife, one of my favorite screen names, Graceful Klutz, Fraudit Terminator, and Boosh McFadden. So congratulations. Welcome to the Church of Mo. We have dark chocolate and sarcasm.
And Zach, I will never. I will miss you when you unsubscribe, but I don't read your super chats. I never have, never will. It's standard policy on this channel. I will never pull up, never read any of Zach's super chats. TT, well, my pleasure, and great show yesterday. And let's talk about a show sometimes. We always say it, but we never do anything. Maybe there's Karen on Friday. Maybe we can do something together after that. But I don't. If you Twitch twat, hit me up. I'll hit you up. I'll slide into your DMs, girl. I shouldn't say stuff.
No, I think it's
and reviewing some
Yeah, I'm an idiot.
of the materials. I don't know the breadth and scope of what was reviewed to you, but some of it may have been reviewed to you based on counsel's representations. State, I want to address with you first, because Ms. Boone hasn't reviewed the discovery yet, as to what your position is with regard to assembling or finalizing an exhibit list or your exhibits for trial.
As far as providing a list of the specific items that the state seeks entry of.
Correct. I do want it before pretrial. So let me just kind of lay the map for what the court's thinking. The court would have the state provide a exhibit list and a witness list by X date. Ms. Boone would have the opportunity to look at that list. We would then have a hearing where all of the exhibits would be shown to and provided to Ms. Boone. They would be provided on a USB thumb drive that could be utilized with a laptop at the jail. And then she could view all those exhibits here in open court. And then she would be afforded the opportunity to make an objections in writing to any exhibits at a later time by a certain date.
I guess one of the concerns would be that if the state identified specific items that we would seek entry of, depending on the course of the trial and the questioning, there may be other items that have already been disclosed in discovery that may necessitate being entered in, would potentially not be part of this original witness exhibit list. Items that were in the discovery, but if that makes sense.
That does make sense.
Yeah.
And I understand what you're saying. And that seems to be more of a fluid situation as to what may happen at trial, right?
Sure. I don't imagine the court's intent would be for the state to just produce the exact witness lists that have already been sent in discovery and just make a notation of every item of evidence. The idea would be to try to pare down.
That's exactly the idea. Now, obviously, that wouldn't.
Mo, what's wrong with you?
Yes. Well, I'm wondering why he's wearing a trench coat, but I didn't want to, since the audio's so bad, I didn't want to jump in while people were talking. But what in the 1980s Blade Runner are we doing here? I feel like,
But
well, he's wearing his, I guess if you want to roll up your sleeves, yes, it's a hurricane, Marissa, but not inside.
No, Marissa, I don't know what kind of house you live in, but the rest of us have walls. The rain and the wind doesn't go inside. Do you see that big thing in the background with the blinders on? That's called a window. Developed countries have those, so you don't have to wear clothes inside your house.
Baker, it's part of a strategy. He's like, Your Honor, I have to leave now. It's raining cats and dogs outside. Let me go.
Yeah, I need to get home. Yeah, but I never understood civilians with that shoulder thingy thing on, because we use it to have our rank insignia in the military. But people
That's
who
where
walk
he's
around
going to attach his flask.
you have that in your inside pocket to keep your whiskey nice and warm.
True.
Please tell me that. And he looks kind of like Jason Statham. But tell me this isn't the look coming back. I would hate that. And his cuffs are way too big on his jacket.
Yeah, I was wondering. I was like, is he wearing a zoot suit? Because it looked so comically oversized. But then I was like, he's wearing a trench coat. Okay, Neo. I guess you're going to have to do that backbendy thing to get out of Sarah's logic, freedom seeds she launches at you. So good luck.
Well, Marissa, men doesn't get cold. And if we do, we just adapt. That's why we always have the thermostat at 72 degrees. No more, no less.
Maybe he discovered CrossFit during COVID.
He has a white tie on. Nope. I'm out. Thank you. I'll look at it when I'm done making fun of Jason Statham's outfit. Today no one can call me misogynist. Today I will be feminist. I don't know. Misandrist.
Thank you for the super chat, Unhung Hero. And why is he wearing a public self-pleasure jacket? Well, he has parks to go to after this. That's why. There's a nail salon over there and a Weight Watchers clinic, and we all get gifts.
Oh.
If something was produced in discovery and something that would not be relevant or admissible at a certain stage of the trial, but maybe later became relevant.
Oh, and thank you so much, Shizzy, for coming through. Marissa, can you share Shizzy's link, because he did this to the audio.
For the state to just
be provided on a USB thumb drive that could be utilized from the Orange County Jail. And all was scheduled.
No, I just have to find the
26th. And
because also
finalizing an exhibit list or your exhibits.
a list of the specific items that state seeks entry of.
Correct.
Audio should be better in this one. Oh, did I? No. What?
He lives in a van down by the river on a diet of government cheese.
Where did the audio go now?
I am touching no buttons.
Neither am. Did I mute something down here? I boosted the volume. Maybe it's. I just thanked Shizzy and now, and the audio was good. Now I'm gonna refresh. It's newly
rather than the Tuesday the 24th. reviewed the discovery yet. And that seems to be more of a fluid situation as to what may happen at trial, right?
I think.
Sure. I
No,
don't imagine the court's intent would be for the state to just produce the exact witness lists that have already been sent in discovery and just make a notation of every item of evidence. The idea would be to try to pare down.
That's exactly the idea. Now, obviously, that wouldn't foreclose you if something was produced in discovery and something that would not be relevant or admissible at a certain stage of the trial, but maybe later became relevant or admissible due to something that happened or something that was said. I would not foreclose the state, nor would I foreclose Ms. Boone from attempting to move that piece of evidence into evidence for the jury to consider. But it would be almost like a civil.
Laura, just as we told Marissa, in developed countries, we do have windows in the windows. So you don't have to fear that the rain is coming in. And I lied, he doesn't wear a white tie. He wears a tie from the 70s.
Maybe he doesn't have a suit coat, like a suit jacket. He was all Twitter-pated about the hurricane. He forgot his suit jacket, and the judge is like, you will not make my court look ridiculous. Get your trench coat.
Sarah has one job. You won't take that from her.
Yes.
Stephen, yes, the audio just jumped way up because Shizzy made magic, took all the bad background noises away. So it should be easier.
Conference where you and opposing counsel would go over what your exhibits are prior to proceeding to trial.
Maybe this is.
And I think that's important to do that so that Ms. Boone has the opportunity to view those in court so that it's on the record as to what she's reviewed, and then give her the opportunity to provide any objections, if any, to any of those exhibits. And again, I wouldn't foreclose you if you want to use items A, B, and C. That's all you intend on using. I don't know what you intend on using. I don't know what evidence you have. If you only want to use and only show A, B, and C, but are saving D.
J.I.N., this is from yesterday, the one we tried to stream yesterday that wasn't live. It went live around 5 p.m. That's a sleepy time for the old guy. So we did it today.
And thank you. Yeah, he's in the Tubin coat, and he has his hand in his pocket. I hope that's his change he's jingling. This truly is a Florida courtroom.
Depending on what happens, I won't foreclose you from readdressing D, E, and F. It's just an opportunity to address what it is you think you're going to be seeking into evidence at this time.
So essentially,
oh no, he's just been told the Corleones have moved on him.
So I think we could accommodate that if we could go around September the 1st for that, and then that would give her an opportunity to review that USB and lodge any objections, and then we could potentially address those objections and go from there.
Okay, and that would be September 1 to have the evidence viewing, for lack of a better word, or for the list to be provided?
For the list in the USB.
Okay. We're going to make this work for an October 7th trial date, Chris. I think September 1st is probably about the right time frame to have this in-court hearing to begin lodging those objections if she has any. My next question is, are you expecting the physical evidence to be brought here into court by a CSI so that she can potentially open it? Or are we just talking about digital evidence and giving her a list of the physical items?
If there's physical evidence that's sought, I want her to have the opportunity to review it.
And we should be looking at the top of the month for September so we can get this.
Okay, all right. Ma'am, do you understand that what it is that I'm discussing right now, so that you have the opportunity to review the evidence the state may be seeking into evidence in your trial?
Is it my understanding that they will supply me with a USB drive and then I am to review it while in court?
No, ma'am. So it's kind of a two-step process. So anything that's digital, that's not.
Jilly, she allegedly put her bite-sized boyfriend in a suitcase while playing hide and seek, and then she went upstairs, fell asleep, forgot he was in there, and he suffocated because of constrictions. Sadly for her, she did tape 2 videos where she says, That's what you get for you tell me. Yeah, that's my name. Don't wear it out. So
Yeah, he was begging to be let out, and she basically had the most chilling video where at the end she just goes, shh. I mean, I don't watch like Seven or I watch Seven, but I don't watch Saw or Hostel, and that was about as scary a thing as I've ever seen in real life.
yeah, she will bring it as evidence and say, I couldn't fit, he couldn't have fit, but we found him in it, not intentionally. Oh, and she admitted to doing it 25 times during the interrogation. So, well, that's why we're here. Ask any questions. We will probably say something or just make another thing up. You're really getting a lot of love today.
Thank you. You know, it was the first day of back to school, and I'm just happy I'm not day drinking, to be honest.
Any longer. You forgot day drinking any longer.
I don't day drink in front of my children. I would do it while they were at school. I'm
Yeah.
just saying if I logicked it out, but I'm just like, there's peace and quiet and no one's coming in to gift me a cat. What will I do with myself?
And Virginia Little, I have thought a lot about it because my 10-year-old nephew couldn't figure it out either. Maybe she put him in the suitcase and she went to hide herself, and he had to get out. And Jorge wasn't that bright. He couldn't count to 10. So instead of him saying 1, 2, 3, I'm coming, they figured out it normally takes him like 10 seconds to get out of the suitcase. So she locked him in there and ran to hide. I would go with that defense.
The only problem with now, I do believe she is going to go on some tangent of DV. She does not project, she does not engender sympathy to most people. And I think any defense you could have is negated by those videos. I would take a plea deal if I were her, but she is going to fight this until the day she dies, because if she changes that mental, trail that she has, and she actually admits that she has issues, I think her whole world would crumble, because she'd actually have to see herself being, a big issue in her life. And it's much easier for her to process the world as, I am a victim and these things happen to me because I'm very unlucky.
Yeah. And we probably should mention too that the evidence from the ME kind of showed she probably pushed the suitcase down a stair. So I don't understand why they believe this case would take 3 weeks. Just so the 2 videos, the ME report, and Sarah admitting to doing it.
I think we are going to get a lot of testifying from Sarah when she's even trying to ask witnesses questions. I think they're putting padding room in there, because we saw, even though, let's say, Daryl Brooks, kind of had a sort of idea, it took him 12 times longer than any other competent attorney would take to do those. So I'm guessing they are just making sure they have time in there in case she goes full sov sit.
Mo?
What? Oh,
I have Josie is the best Snoop around.
Oh. Before, when she had a soul. Yeah. She doesn't even look like the same person. Okay, well, now she kind of looks like a person that's going to ask for your manager.
But look at this beautiful young woman. Straight A student. You can tell her cheeks and jawline is the same. But she did have the fluff. Not the full fluff, but she did have the fluff.
Yeah, I mean, I don't know what in her life led her to this hair helmet, but there were obviously a lot of terrible hairstylists in her past, or she does it herself with a Tupperware bowl.
Well, I think alcohol is the main culprit.
True.
And someone was asking the time frame. I believe it's murder 2, so I think that's 30 years to life.
Forensics or CSI or something that's tangible will be provided to you on a USB.
Tim Swoop, don't go to high school and look for women. Just
Yeah.
don't do it.
You know, what is that? Dazed and Confused. Matthew McConaughey is not an idol that you want to live up to. Every year, the high school girls stay the same, and I get a bit older.
Yeah.
That'll get you a felony.
Hey, Quinny. Yeah, it wasn't poofy enough. I'm copying you. Well, stealing is the best way of flattery or something.
Yes.
We also will have a hearing where all of the evidence, including any digital, electronic evidence, or any tangible evidence, CSI materials, will be shown to you in court, played to you in court, so you have the opportunity to review it here as well. Anything else will also be given to you on a thumb drive for you to review at your leisure based on the hours of 8 to 4 by the laptop at the Orange County Jail. Then we will have a deadline after we have this evidence viewing for you to identify in writing any objections that you have to any of the evidence that's been provided by the state.
So it's not a matter of any type of confidentiality. It is all done in the courtroom with everyone.
It would be in the courtroom, correct?
Are there going to be use cameras and photographers?
That's something I need to address. I do not want.
Thank you for the super chat, Zach. I didn't realize you're dual streaming. Are derringers involved? Anyway, here's a little tip since Baker doesn't read your super chats. Well, once I get my office or my room/office redone, I will restart doing the murder board super chat recognition. So thank you, Zach, for that super chat.
That's better. But the other, don't say the other thing, especially in this day and age. You will get clipped.
Yeah.
I talked to my tattooist the last time I was down getting my tattoo, and she said the big problem we have with older people thinking tattoos are kind of cool is the amount of cigarettes and alcohol and sun, because in the 90s we took a lot of sun. She said their skin is just like parchment. It's so hard to tattoo. So
oh, wow.
Don't drink too much, people.
Because our jury pool is going to be coming from Orange County, I have concerns about media's presence in the evidentiary viewing. So I may have to enter an order which would prohibit media access for the purposes of that hearing due to the nature of what is being produced and reviewed, so as to further prevent intimate details of the case being released prior to trying the case.
Understand that, Judge. Ms. Boone, not to turn the page completely, but I think it's pertinent to this discussion, has indicated through some counsel that had met with her recently that she wants to talk to the state out of the jail. And I was going to discuss that at the end, but perhaps to not waste the court's time, I don't know about bringing physical evidence out to the jail, but as far as the digital evidence, which will include autopsy photographs, which will include crime scene photographs, which will include videos, perhaps a different suggestion, especially since she has an investigator from Prison Break, is that we identify those files that we intend on introducing at trial so that they can review that digital evidence on their own in the jail. And we're not publishing all the digital evidence here in open court. That should allow her the opportunity to lodge any potential objections, such as duplicative or any other objections she may want to raise about autopsy photos, so on and so forth, without exposing all of the digital media to the public. As far as the physical evidence, the state doesn't have any real concerns about the media covering that. She can open those exhibits, or somebody with scissors can open those exhibits for her for any exhibit she wishes open. In the witness box where it's concealed from the media's eyes. Those are my suggestions. And then later we can turn to her request and put on the record how we would go about going out to the jail and meet her.
The only concern that I have with that is I don't have a record as to what it is that she reviewed.
My suggestion would be that because this is in the context of plea negotiations potentially, I would be out there, Mr. Cacciatore would be out there, and our investigator would be out there, and we would record it. The conversation that we have, of course, and that would all be protected because it would be in the spirit of plea negotiations under the evidence code. And then we can all file in writing, the state can file in writing, these are the videos that we are going to use. These are the particular photograph numbers from the crime scene and from the autopsy photographs that we're going to use. And then we can have.
Jury number 24. Did you ever have a really good day where you did puzzles and then you started to play hide and seek? You listened to music. It was a good day. Did you ever have one of those days? No.
You know, I
I'll
think
strike
I'm going
that
to
one.
record Mr. Mo's face on date night Wednesday when I tell him, I just bring out our largest suitcase and tell him we're going to play hide and seek for science. And he's going to say, if I'm in the suitcase, don't you know where you hid me? And I'm going to say, not with the Sarah Boone rules. Now, let me drink this bottle of wine. We have to follow the rules.
Yeah, Sophia, but the judge is a fast talker, so I'm a little bit afraid to put him at 1.25. It's kind of like that where you could just put it up a little bit. So
I do like that they are taking the time to explain everything and get Sarah's affirmative, statement of understanding. So when she writes her 85-page next, rebuttal letter,
yeah.
We all saw this hearing and we saw her say, I understand. And they're breaking it down and explaining it in lay terms. So it's not like she can say, I just don't nothing happened.
Is there evidence you threw the suitcase down his ass? Well, the suitcase had been flipped over and there's some indications on his body that might be consistent with going downstairs. But on my Discord, I think Josie put up the autopsy photos yesterday. And Jess will still kill me for calling her Josie. What's my favorite Danish? It's a cream Danish. And anyone who says cheese Danish will be blocked on this channel forever.
Yes, if you're new to this channel, Baker has a deep and fiery hate of 1,000 suns for cheesecake and cream cheese.
And cheese Danishes.
And cheese Danishes.
Well, they are doing what, again, they are communicating, but they can't guarantee that it goes in between the ears.
Yeah.
She is still having her 14th Amendment violated. Well, the judge's ruling says no.
Yeah. And maybe her 19th could be violated, but no, she can still vote in prison.
Well, can felons vote in Florida? Oh, she's not a felon
she's not
now.
technically a felon yet.
Yeah.
Kind of sign off on that as well, so that it's documented as to what was told that she would be facing at trial, and either she can review it with her investigator or she can review it with us.
100%
being present, and then that way the digital evidence is now open.
Okay. Ms. Boone, what are your thoughts on that?
I'm a little lost. So it's an option of reviewing what the state has with my investigator and then be able to come with the objections and everything.
That's correct.
I'm clear on having all of my evidence being in sealed bags and for me to be able to inspect them to be here in the courtroom. I don't know how the attorneys have done any of this prior, but I don't believe that it was in the courtroom. So I'm just trying to protect myself against the media. I'm not sure at this point what is even suppressible that is available on the internet. But at the same time, though, it is my understanding that I should have some right to privacy in reviewing my the evidence. So I didn't know if my investigator and I are able to collaborate prior and then come to work with the highlights and ready to go answer.
I'm certainly going to give you an opportunity to meet with your investigator to address it. The question is just the method of how to do it. The state's proposal is digital. They would meet with you, identify specifically digitally what videos, what photographs they intend on utilizing, and anything that may be physical, CSI, et cetera, would be addressed here in open court.
Just so the court and the defendant understands how physical evidence viewing would operate normally, the defense attorney and or her or his investigator would come out either to the sheriff's office or OPD's evidence center, whichever agency, and they come and view it. But it's done in the presence of the state, it's done in the presence of law enforcement, it's done in the presence of the CSI for the chain of custody. So attorneys don't get privacy when they're reviewing the physical evidence either. So that wouldn't really be any different than if she's doing it in the witness stand or wherever deemed suitable.
I think that's the most appropriate way to have the opportunity, ma'am, to review the evidence. I can't release that evidence to Mr. Lane to bring to the jail for your review because of the chain of custody issues concerning some of the physical evidence. So CSI would have to be here just like an evidence viewing at the sheriff's office or elsewhere where counsel just identified. And I cannot bring you anywhere else other than here, and I can't release you to anywhere else. So I think the only solution that we have is to have the evidence viewing here with regard to any of the physical evidence.
I do think not having the media there is a good idea.
Because I cannot make a record anywhere else of what you saw or what was reviewed. The only opportunity for me to make that record is here in court.
What did prior attorneys do?
That was already identified by the state.
I know I'm trying to keep up with everything. What was the answer?
Oh, we have a question.
So, an attorney.
Hot Wang, this is Sarah Boone. She, in the guise of playing hide and seek, put her fun-sized boyfriend into a suitcase, made videos of her taunting him while he is saying, "I can't breathe, you know, I'm very uncomfortable." And then she went upstairs to go to sleep. There are alternating theories that she abused him while he was in the suitcase and unable to get out. But the primary cause of death was situational asphyxia or positional asphyxia. So the videos pretty much mark her as guilty, but she has gone through 8 lawyers, some that were recused because they were part of her ex's defense during DV cases against her, and many because she is just insufferable. The court has ruled after her 8th attorney that she will be pro se, and yes, I did, allegedly innocent. But she is, she's very disagreeable. She's very headstrong, and she is famous for writing just copious letters to the manager, the judge, to tell him how to do his job.
Clearly, you didn't read my letters. It's always a good line to use on a judge.
Clearly, you don't understand my brilliance.
Yeah. No, I'm not going to tell this now.
Who's doing an evidence view would come out to the law enforcement agency's evidence warehouse, for lack of a better term. And then in the presence of the state attorney, the CSI, and the lead detective, they look at the package, and if they deem any particular package worthy of opening and examining, they can do that. We can have the CSI bring butcher paper here so that any particular item can be opened, put on fresh butcher paper, and then changed out between exhibits so that there's no contamination. And then you can examine it. If Mr. Lane or any other representative from his organization is here, he will have the opportunity to photograph those exhibits once taken out of the packages. And that's essentially how an evidence viewing is conducted.
Thank you.
You're welcome.
And again, please, would the media be involved in that?
That's a conversation that I need to see if I can exclude them from participation or viewing that proceeding. There are rights where the media has to view proceedings in court, but due to the sensitive nature of what may be being discussed or viewed, I need to see if I can prevent media access. So without doing a little bit more further dive of research in that, I don't know if I can make that call at this time.
Yes, I have not heard of a case where the evidentiary hearing has been televised. So if you could please look into that, I disagree with the media being involved in that.
I understand your position, and again, for the reasons that I stated earlier, I'm trying to prohibit as much as I can from the dissemination to the public, especially some of the exhibits that the state may be seeking to utilize. we are going to go ahead and set the evidence hearing. The first is Sunday. September the 1st is a Sunday, and that is Labor Day. The court would be setting a hearing for Tuesday, the 3rd at 9 a.m. to have the physical examination here in court. At that time, in the USB drive or the after our viewing here in court stays at your position to then have that meeting with Ms. Boone and her investigator and your investigator under the plea negotiations or settlement discussions auspices to review all the digital and identify what it is specifically.
We are happy to defer to defense wishes on that. And I want to have that discussion. It seems like we're turning that discussion. So I'll leave it in Ms. Boone's court. My indication from one of the attorneys that she had discussed things with said that she wanted to have a conversation with us. And so I'm offering that up. In the past, with female defendants at the Orange County Jail, there are classrooms, or at least one classroom there, where we could arrange to meet. It would be a big enough room for 4 or 5 of us that would need to be there. And then we can discuss that, whatever it is she wants to discuss, and it would be recorded. And again, those portions of the conversation that are about plea negotiations and the evidence and whatnot in the trial, I believe under the evidence code would not be admissible to be used against her. And I leave it to her when she wants that to happen. We can make arrangements to try and accommodate that. It should not take us very long at this point, given the age of this case, to select and identify which digital evidence we're going to use. It's simply a matter of getting rid of duplicative and irrelevant photographs from the scene and the autopsy.
The videos were found on her phone the next day by the police officers. I'm not sure if they are on my Discord, but you can find some you can find them on YouTube. And let me just tell you right now, I do this a lot. If you, I don't like doing trigger warnings because you're not snowflakes, but
Yeah.
they are harrowing to listen. I think that's the word, to listen to.
Yeah.
It's a demon talking in those videos.
Yeah, it's chilling because you can tell he's panicking. You can see, him pushing on the suitcase, and she is just like, that's how you feel. You cheat on me, and then that's my name, Sarah. Don't wear it out. I mean,
Yeah,
it
it's
is
the
horrifying.
that gets me.
Yeah, because after that she just walked upstairs and went to sleep.
Yeah. If you don't, if you have even a snippet of a soul, don't do it. You will hear it in court. And again, I do a lot of cases. It doesn't really touch me to hear a lot of the gruesome stuff. Kind of like yesterday when Better Road talked about, don't get it wrong, but if you're in the business, the Karen Reed case isn't. Because it's just a hit and run, and a lot of murders are just murders. You get used to it watching it, but the utter disrespect for that man who was begging for his life, that does something on a deep level, because you can kind of just make fun of someone doing something and someone passing away, but this one, she intentionally did it to him, and he is begging for his life, and you can
Yeah.
hear he can't really breathe, and he's crying, whining, and she just says, "Shh."
Yeah.
It's not good.
And a lot of times, if you dig into cases, we find a lot of things where maybe the state may not have all the evidence, or there's a chance that this person could be seen as, not guilty. This woman is the type of person you love to not like, because she is just terrible.
Yeah. Yeah, and that's between the two videos, she have turned it over. So I forgot it was there. No, it's really not a good video.
No.
Yeah, you could say that, Laura, but it's also very important evidence. But
Well,
you
yeah.
all the warnings on it. Don't watch it with your kids near, and don't watch it if you are planning a date night hide and seek game with your husband, and if he's snack sized. Or maybe learn how not to take videos.
I believe, I know I have the autopsy report because I was trying to make sense of that and color shade things. I believe he was 5'1" or 4'9". It was
Yeah.
something, he was fairly short.
Yeah, and around 110 pounds or something. He was snack sized.
Yes.
I believe the videos might be too hard to decide which ones to use. I don't know that there's a whole lot of other digital evidence.
Okay. All right, ma'am, do you have a thought on when you would like this viewing to take place at one of the classrooms at the Orange County Jail under the concept as identified by the state?
So this meeting is separate. This is prior before everything else.
Yes, because they found him in a suitcase. So I would believe it. Because make it make sense without the video say, I locked him in a suitcase to play hide and seek and went up to sleep.
And I mean, I guess that wouldn't be so weird if he didn't have corresponding other injuries that look a lot like he either was flipped around in the suitcase or he wasn't able to defend himself. Excuse me. So there's a lot of injuries that I'm reading, and he had it is very hard to get bleeding both. So under your bone, you have a thick sort of layer of tissue that disconnects the brain from the rest of the blood system. So you can't get some harmful substances into your brain. There was bleeding both above that and below that. And you have to be hit pretty hard for that. Not that I'm a doctorologist. I've just watched many of these cases.
No. Yeah. She opened it because she was doing CPR when she did her 911 call, which she wasn't. You could hear it in her voice. She wasn't doing anything.
You would be out of breath. I mean, it is hard physical work. I had to learn CPR for babysitting, and it's to keep it going for minutes and minutes. It is not easy. It's physical.
Yes. We are both students right now at the Sarah Boone / Darrell Brooks School of Law.
Yes.
Yeah, there's no evidence of CPR done in the report either. She is, and she called her ex-husband to come over and fix the problem before she called 911. And he smartly enough said, I'm not. Nope. You fix this one.
Yeah, he was like, I didn't even step inside once I went through the door. I'm out.
She has a ticklish brain and probably belongs in the nervous hospital. She has been evaluated and found sane. She's just an annoying B word.
What I would envision, to not waste anybody's time, is we can go out there and have this discussion. If there is a discussion we had about plea offers, one of the other topics was other matters. So that's kind of ambiguous. I'm not sure what other matters are. And then also we can let her know and probably provide the court in writing a list of the digital evidence that we seek to introduce. And that way, if she wants us to review those digital evidence items together with her in the presence of everybody, we can do that. Or we can let her, with the list of the digital evidence that we plan on introducing, review that as many times as she wants by herself and or with Mr. Lane.
I understand. So will I be leaving with the digital evidence today, or how soon may I receive that?
So the state needs to assemble that. So my thought would be to have that meeting, ma'am, on the 3rd of September. So we would have a hearing at 9 o'clock in the morning where the physical evidence would be reviewed here in the courtroom. As soon as that evidence was finalized and reviewed, the state with their investigator, yourself with your investigator, would then meet that afternoon at the Orange County Jail to address, as the state has identified or spoken about, any settlement negotiations, plea offers, and under the other category to address what the digital exhibits are. They would provide you those on a USB drive. and they would identify for them specifically what it is that they are seeking for you to review at that point in time and have the ability to review it afterwards.
We're happy to do that beforehand, and I just want clarification by providing her the USB.
And Paul, the people say she should take a plea deal. You just heard it. That is where they will talk about a plea deal. So I would take it. Get the 25 years in the slammer, and you might come out and see sunshine again.
Yeah.
Anita Martini says, I got that one. I need a martini. Her filming her act of violence and Archer is curious. Like she wanted something to remember what happened. In my opinion, it further proves she planned the whole attack on Jorge. Yes, it was deliberate. That's why it's... And again, just show that video and say, we rest, Your Honor.
Yeah,
Because-
I don't see this taking more than maybe a week and a half, even if Sarah pulls out every single person she used to know and her Sunday school teacher.
And she actually claiming spousal abuse. She did in the beginning. They were looking for an expert, but no one was willing to do it for the amount of money they were offering. So no way she's granted a plea. Well, they don't want to waste 3 weeks in court, so they'll probably give her one. The lividity would show how long he was on his side, as in blood on the body going to the lowest part. Anyone know how long he was in there? Well, lividity is kind of, it depends on the temperature and stuff like that too. But the autopsy report is in the Discord.
I think he was in there a good 8 or 9 hours.
Yeah, I think the videos are from around midnight, and she calls 911 around 1.
Yeah, 1 or 2 p.m. in the afternoon.
Yeah. I heard she was looking for a hide-and-seek expert, but as you can imagine, they are very hard to find. John Gary.
Where's Waldo? Would not answer her summons. Carmen San Diego either.
11 hours, the lividity was on the left side. Thank you so much, Jess.
Discovery, are we providing it to Mr. Lane? How is it?
It would have to be provided to Mr. Lane, who would then have to provide it to a member of the staff at the jail, the names of which I have from the captain at the jail, as to what persons are involved in the laptop process. And then once that's done, I would require Mr. Lane to identify with a filing in the court, probably in the form of an affidavit, as to when, where, and how the USB drive was received by him, and when, where, how, and to whom it was delivered.
Your Honor, I feel uncomfortable with you all supplying my evidence to the jail. So I don't know if there's a way that, I don't know if you are aware, but my jail phone calls have been released, and there's a lot of things that have been released from the jail. So I don't know. I do not feel protected by you all handing it to the jail. I know that Julian and I previously had worked on the laptop with USB drives that he had furnished himself from bringing it from the outside. So I didn't know, and I was more comfortable if there was a process or procedure. I don't know who your names are from the jail. I do know the captain who I spoke to the other day regarding my laptop. But I was very much.
Who was that, ma'am?
I'm sorry?
Who was that?
For which?
The captain that you spoke to. Who was it?
P. Giovanni.
Okay.
There's multiple sergeants involved, and I did meet John. He was supposed to be here today to pick up USB drives. So I don't feel comfortable, please, with providing the USB drive of my evidence for things that have been leaked or released from the jail. So if there's a possibility, please, I would like for my investigators to have that and bring it with me prior.
If I understand the jail's protocol, which I read to you at our last hearing, the jail will keep custody of the USB drives and release them with the laptop as well. So I don't know how I can bypass that process that they've created, because the USB drives in the laptop, when it's checked out by you and when it's returned by you, is all going to be logged in their IMS system.
Right. It's simply a laptop. It's a very basic laptop where anyone affiliated with my case has any type of digital evidence they bring in with them from the outside. It's simply a basic laptop that we are able to utilize at the Orange County Corrections Department. That's how we have done that prior. So I don't know what it is different. I don't know the jail protocol because no one included me.
You were provided a copy of it through the court filing, and I read it to you at the last hearing.
Your understanding is different than my understanding, because my contacts with the jail are telling me something different.
Who?
There's-
What are their names?
There's multiple sergeants.
What are their names?
I'd rather not get involved with their harassment or anything else. Other.
Ma'am, I'm deferring to what the Orange County Jail and the captain that you identified specifically as to her memorandum to the court, which was read to you at our last hearing, which was sent a copy to you by a notice of service, and it was provided by U.S. mail. It was sent out last week.
I didn't get to receive anything such as.
Don't worry, I have a copy to give to you this morning, just in case you have not received it.
Yes, the last thing I have is your order that you provided me with the implementation of the USB drive.
Okay.
Option.
All right.
So anything that you were speaking of in the meantime, I do not know if it was served by process,
It was served by U.S. mail.
by US mail. Yes. I actually have 3 motions, please, if I may submit them to you.
In a moment.
Yes, in the process of, because the address that you are, I'm guessing, sending these to is incorrect.
I received your letter addressing the address issue. That's been remedied. So the appropriate legal mail address will be utilized. It was simply a clerical error, and that has been remedied. But regardless, I did read to you at our last hearing the protocol for the USB drive in the jail. The court is inclined to follow the Orange County Jail's protocol with regard to the USB drives. So the evidence, digital evidence that the state seeks to admit at trial will be put on a USB drive, delivered to Mr. Lane. That will be delivered to a representative from the Orange County Jail. And Mr. Lane will thereafter file a filing with the court in the form of an affidavit identifying when he received it from the state and who he gave it to, when he gave it to, and what representative of the jail he gave it to.
So it goes from the state to Mr. Lane to the jail.
For the purposes of indexing it, for the purposes of their records, under the protocol, and then it will be available for your use.
So if I want to see all of my evidence digitally, I need to contact someone at the jail.
No, ma'am. The evidence that were in the 2 bankers box that Mr. Lane digitized for you is going to be provided to the jail. That's going to be provided with the laptop.
She's not listening to one single word he's saying. She just shut off. You could see it in her face. He's talking to me
What
like I'm
she
stupid.
wants to be told is you get a private room plus a law library plus this ensuite for you to do your legal stuff.
Yeah. But she was clearly told the last time from 8 to 4, you'll have access to your laptop and the prison library. And now she's sitting there saying, so I have to talk to someone. Someone told me that. Who? I'd rather not disclose that.
Yeah. Is she the New York Post, sources close to the situation?
Hey, Lindsay. Welcome. Yeah. But you could just see her face. That's the face I used to have when my mom started talking about. She went down to that girlfriend, and it was so amazing. They were talking about this fabric that they were going to sew something for the kids. It was so amazing because then her husband came home, and I just sat there and turned into mode. That's a mode we men have. So a little trick, ladies, when he's saying, interesting, he's actually thinking the Mets should really get a new pitcher.
It's like when Mr. Mo or the kids try to explain Roblox to me and their new, special super, bad guy thing. And I'm like, And then I'm thinking, I really need to rotate the laundry. What are we going to have for dinner? I should probably pull out some ground beef to thaw.
Why shouldn't she get a private room? Well, she has access to the prison library. What she doesn't have is access to her private room outside of 824. So she has a full day of work. She can work on her case in the prison library, where she will be afforded a laptop, because her complaint was she's sharing a bunk space with 65 other inmates, I believe it is. And she wants to work on her case at 2 a.m. And she was told, we can't do that because we can't give you the hard copies in a joint room and it'll be on a laptop. But I want to draw on my hard copies. And they said, you can't. But she didn't listen to the part that they said, you will have 8 hours a day working on your case.
Yeah.
I think she could use a drink right now. Yeah, probably. Well, you just need books, book of law. I don't know if they have puzzles in jail. I bet you if they have, one piece is missing in every set.
Probably.
Yeah, she has 8 hours a day, 8 straight hours she can work. That's more than any of her attorneys would put in.
Yeah, I do kind of wonder about, and I haven't watched the video, so I'm not making any assumptions, and I like to hear other points of view. But I do wonder about the attorney who went to visit her and, is arguing that she deserves another attorney. I do wonder about his presence in the hearing now. Is he going to now step up pro bono? Or is he going to be her effective wing person for laws? I don't know. It seems rather odd to me that an independent defense attorney is kind of tangential right now, instead of either saying, hey, I'll take your case pro bono. He's kind of there on the periphery.
Laura, I don't know. Do you want me to go on YouTube, go back in my live stream to where we talked about the height? It was John Gary. If you're looking for the guy who made the great comment about they are hard to find, it was John Gary who made that joke. He won the joke of the day, Zach. That's why I don't read your super chats, because John Gary is funny. Oh yeah.
And that's available to you from 8 a.m. to 4 p.m. every day in the protocol that I read to you at our last hearing.
Yes, and I will speak to the captain just to be aware that everyone that it is in the process, because I do not feel comfortable with any of this, and I do not feel protected either by the court or the jail system. So for right now, I don't know if it can be postponed or if it's something that I need to write another letter to. Everything takes longer in jail, so by me trying to get a hold of the captain nonetheless, it's going
That's why my girlfriend's always said, should we stay a night in the jail?
to be a feat in itself. So I want you to know that anything that I am in the process of trying to reach out to the captain, I don't know if she'll be here today or if it'll be the contact person. So in the process, I am working on speaking to the captain because I do not feel, like I said, that I am protected in any way, shape, or form by the Orange County Corrections Station withholding my evidence in any way, shape, or form.
Okay. The court's going to follow the procedure as I outlined at the last hearing. So here's what we will do. We will, on Thursday, September the 3rd at 9 a.m., we'll have a hearing to review the physical evidence. At that time, the state will provide its exhibit list, which will be filed with the court at that time, and a copy will be given to Ms. Boone of the physical and the digital evidence they are seeking to admit. After we have the in-court examination of the physical evidence, that afternoon, there will be a meeting at the Orange County Jail between the state, its investigator, Mr. Lane, Ms. Boone, to review the digital evidence and provide a USB drive with that information.
You can caveat in that order view, unless it hasn't already been done. In case we do it ahead of September.
Sure, if you want to do it before, the deadline to do it will be to September 3. But the in-court physical examination will be at September 3. So if you all want to meet in advance of that, I won't prohibit that. Just file something in the court file identifying a notice or some document so that it identifies when that meeting took place, when the evidence viewing took place. Okay, thank you very much. Ma'am, after we've had this hearing on September 3, and that being the deadline for the digital evidence and the viewing of the physical evidence, the court would then like to set a deadline for when you would provide your objections to the state's exhibits. Mindful that this will take place on September 3 and that we have pretrial set for September 26th. And if we need to have a hearing with regard to those objections, my thoughts would be to give you 2 weeks until the 17th to lodge your objections. And those would need to be provided in writing by the 17th. So that if there are objections, and if we need to have a hearing on them, that hearing can be held when we have our pretrial on the 26th. That would give the state ample opportunity to prepare for any of the objections that you have.
Good evening, and thank you for your patience, everyone. So on September 3rd, I will be viewing the digital and physical evidence here in the courtroom.
Correct.
And then later that afternoon, I will be meeting with the state and my investigator.
If they don't meet with you prior to that date. The deadline for the state's investigator, your investigator, and yourself to meet to review the digital evidence would be no later than the close of business on September 3. I've outlined for when I would like it done, but if the state wants to meet you in advance of that date, they can do so.
Yes, please. If I may ask, please, what's your name, sir?
Will you get?
Could you spell your last name, please?
J-Y. Don't get this.
And what is your affiliation with the state?
I'm on site chief.
He's going to get so many letters now.
Oh, she's already got 5 pre-written.
Our meeting is free on Thursday.
I assume you have availability. Should I meet with Mr. Lane to discuss his availability so we can get out there this month?
Yes.
Then you can do that. And like I said, Mr. J, if you can follow that notice, just to identify when, that would be most appreciative. So ma'am, understanding where we are with the viewing, what is September 17th for the deadline for your objections acceptable to you?
Yes, and if I may please raise the point that I have a motion here in regards to one of officer looking at the laptop. I do not have my discovery as of yet, and I do not have the laptop as of yet. I do not know what hiccups may be involved. There's a lot of hiccups with the jail already. So I'm trying to figure out when and where I'll be able to view anything. So there's a great restriction also that is being put on the laptop usage from 8 to 4. I'm unable to utilize my time to the full extent. Also, I have a motion here to receive my hard copy evidence because when the laptops are in quote, laptops in quote, closed for today at 4 p.m., I can therefore pick up using my hard copy evidence.
I haven't had the opportunity to review the motions that you're speaking of, neither has the state. We'll address them today. I don't have a problem doing that. I'm just not going to do it right this second because I haven't had the opportunity to
What
review
part
them
of the judge can't tell the jail what to do? Are you not understanding? I recognize English. Baker speaks 3 languages and he can recognize it. So what is it that you are confused about?
But the computer closed and she needs her hard copies.
It's like talking to a 4-year-old. No, we are not litigating this. You're getting the red cup or you get nothing.
But I want the green cup.
Well, then drink with your hands.
But I always use the green cup. I'll
It's not
write this.
available. If my kids could write Yelp reviews, my youngest, the blue paint was not available. 0 stars. Do not recommend this house.
It's I'm going to write a strongly worded letter to the judge claiming I need the green cup. This is racial profiling.
Just letting myself in the meantime, please, so you're aware of what I had already thought of and I'm trying to ease the pain of everyone with me trying to figure out how to do everything and when and do it appropriately. But I just wanted you to know that via screen, I have a drive, I have that to also be looked over.
Okay.
9/17, if that has to be changed, and I okay to do that?
I'm trying to set deadlines now, ma'am. And I will give you 2 weeks to review the physical evidence. You'll be provided the digital evidence, it seems, in advance of that September 3rd deadline. And that may give you more than 2 weeks to review and lodge any objections.
This is just for the evidence?
Correct. This is only addressing any objections to the evidence that the state seeks to admit.
The digital discovery, is any of that included in that?
Yes.
Okay. I'm very weird to make these type of deadlines.
Well, we're setting them today,
I understand. So the 3rd is a what day, Thursday?
Tuesday. So the 17th would be 2 weeks later, Tuesday the 17th.
And that is me coming with my objection.
That would be you filing your objections in writing with the court. And to the extent we would need to have a hearing on those objections, we would have them when the pretrial or trial case management conference is set at 9 a.m. the following Thursday, the 26th of September.
I'm sorry, what is on the 26th?
That's when we're having our pretrial or trial case management to address any last minute issues regarding trial.
Forgive me. So today being August 5th, I'm supposed to expeditiously complete my case that in every way, shape, and form by September 26th in order to go to trial for October 7th.
The dates are what the dates are. September 26th is the trial case management date. October 7th is the trial date.
So by me not even seeing my discovery yet 2 days and only being restricted to a laptop from base 4 and not having my hard copy evidence.
You have 62 days to prepare for trial, not including today. And you're going to get your discovery today.
Oh my gosh, he's about to turn this trial around and no
So
one's going to get
in
across.
over 4 years, it comes down to me representing myself in 62 days.
I'm not going to answer that question.
Am I supposed to?
What now we're addressing, ma'am, is September 17th.
Right.
The deadline, which is 2 weeks after having the physical view of any of the physical evidence. It sounds like Mr. J is going to try to meet with you pretty promptly regarding the digital evidence. So you'll have plenty of time to review that in 2 weeks at a minimum, or 2 weeks at most, rather, to lodging objections to the physical evidence.
I understand. I just don't understand how to file objections.
I cannot answer that for you. That would be me providing you legal advice, which I'm prohibited from doing. All I can tell you is that if you have objections to any of the exhibits that the state may seek to move into evidence,
It was the blue-eyed white dragon lady, I believe it was.
Yeah, the blue-eyed white dragon. Which I'll take things that were never said for 500, Alex.
And hey, Joe, thank you for the suitcase super sticker. That was an appropriate super sticker for this case.
Yes.
Blue-eyed white dragon lady. I believe that was the words. But there was so much stress with his ex-wife, and she always wanted money. You didn't have money. Because you were always begging your husband for money. Well,
That's a job. Panhandling your ex.
Yeah. That's Thank you so much for showing Mo a little love, Sophia.
Thank you.
Very nice of you. Blue-eyed white dragon was my favorite Yu-Gi-Oh card. Won a lot of matches back in the day.
Oh.
The courtroom is eerily empty. Well, it's a big courtroom for this, and they don't give her a microphone. It's really annoying.
Yeah.
Look, she's going to object to the entire case and claim Jorge is still alive and that they made it all up. At this point, I believe you.
I wonder if she's going to go for that, the full sovereign citizen. What was his name with the Dragon Ball Z hair? And he was like, the state has lied to you. And I will prove.
Reginald the Third.
Yeah. If she's going to go for a crazy defense, I hope it's a vast statewide conspiracy between, the state of Florida and Samsonite.
Yeah, and I love that he, doing his closing, says, yes, I did it, but they didn't ask why I did it. It's always a
He
good...
got him.
Son, did I hurt you? Yes, Dad. How? When you stabbed me. Probably not the best witness to call for the stand.
It was a gamble, and he rolled a 1.
Snake Eyes, damn it.
We'll have to lodge those objections by the close of business on September 17th. Those objections will have to be in writing. If we have to have a hearing on those objections, that hearing will be held on September 26th.
Okay. And if I may ask, are these being delegated or I'm being incorporated in this in order for me to be able to say yea or nay?
I don't know what that means. What do you mean delegated?
Are you delegating to me as you delegated everything else in regards to taking my counsel and all of your orders?
You are representing yourself for the reasons that the court identified in its 16-page order. It is your responsibility, as you are representing yourself and proceeding pro se, to comply with the court's orders and deadlines. So if you have objections to any of the exhibits that the state may be seeking to offer into evidence, be it digital or physical, based on your review of those, the deadline to submit those in writing would be on September 17th.
Okay, so you're making statements, so I don't have any say in it.
I've asked you what your thoughts would be as to when. You've never provided me in a disagreement with regard to that date as of yet. You've asked questions about your motions that I haven't seen yet. Your desire to have hard copies, which we addressed at the last hearing, but I'll be glad to address it again today. You have yet to tell me that that date's unacceptable for you, and if so, why?
I wouldn't necessarily say unacceptable. I'm just uncomfortable with agreeing to a date when I am pro se and have never been pro se before and do not know what I'm doing. So I just want to make sure that I do it correctly and have an understanding also if you are proposing that I go to trial within 62 days that I know what I'm going into and what I may expect. So I didn't know if this would just be easier on everyone else if they just delegated the date and gave me a printed copy with your order and whatever information you have. I don't know. I don't know either if you all are just proposing that because I'm incarcerated, just the dates are what you tell me. I don't know what I'm doing. I don't know. I do not know what I'm doing. So I'm trying to learn as I go, which is why I'm grateful for everyone's patience. But at the same time, though, for me to accept this date and then not be able to meet it, what happens when that happens, if it should happen?
I can't answer that question. Again, that would be me providing you legal advice as to what to do if something happens. I simply cannot answer that question. I'm not allowed to.
Sarah, you're going to get a packet.
Well, I'm with the court, so whatever it is that you all are trying to do in order to expedite this even more than what's being expedited, I'm guessing I agree with September 17th.
Okay. All right. I mean, I believe that takes care of all of the deadlines with regard to the state's exhibits. Now I want to address the deadlines for any exhibits or witnesses that you may be seeking. I am mindful that you will be receiving the discovery today and that you have not had the opportunity to review some of the items that may be in the discovery. So how much time would you like to provide to the court the list of exhibits that you may be seeking to enter and the list of witnesses that you may be seeking to have testify in a defense should you choose to put one on?
Please understand that I do not have access to a normal phone. I don't have access to a normal phone at normal hours. So I am trying to overcome the hurdle of trying to, number one, locate any of my witnesses, and then also try to communicate with them on a payphone only telephone call that I do not have regular access to, and that limits to only 15 minutes that I have to share with 62 other inmates. That is a hurdle please that I need to please take into consideration in order for me to be able to try to determine my witnesses, to determine any expert witnesses. May I ask, please, does the laptop have internet access?
I'm unaware. I'm unaware if it does.
To view any documents?
I'm unaware. I can't answer the question that I don't have an answer to. I'm unaware if it has internet access.
Who is it that I need to speak to in order for this?
We may be to inquire of the jail representative who is appearing for the hearing this morning, and if not, the captain may be able to provide that information, but I do not know if it has internet access.
May I ask
Can you
for
imagine if
contact
Ted
names for the
Bundy
jail?
was this insufferable?
Give us 1 second.
I mean,
Please.
Ted Bundy was self-represented. Richard Alcala was self-represented. Bradley Yon was self-represented, and he wasn't as insufferable, even though he is disgusting as a human being.
Yeah, it's is she understanding any of this, that she's just sitting there and constantly carinating? It's just, oh, to expedite what you already expedited in a more expeditional way, I have to agree with those dates. It's not like you're going anywhere, honey bunny. It's not like, well, I have that week in Bahamas. It's gonna be really annoying if I have to come to court that week, but I'll make it work. Can I get some internet? Nothing comes in.
Yeah, she is not in listening, accepting, receiving mode. She is in I will over Karen you mode.
Kurt said he thought she did really well in this hearing. I didn't see it. I don't know in which setting and which context it was given, but so far all she have done is say, "But Your Honor, it's not fair."
Pretty much.
Yeah.
Again, he is a judge only in the courtroom. He cannot be, he can't tell the judge or the jail how to work things. These are questions that she does not understand. He is not like God of the universe. She thinks he's the district regional manager.
Yeah. No, they mentioned that the latest they can offer her plea deal is the 26th of September. She's annoying, plain and simple. Yeah. Didn't the JOA already cover this with her? They will work her through filing motions, etc. thing. they will give her a pro se package. Someone asked who was the guy on the screen. That's the JOA. They will give her a package, and she has been told about her computer. I believe in the last hearing, the officer, I believe, at some point talked about what she would have access to, but she wouldn't get free access to the internet. Imagine her with an email, Your Honor, it's 8:01 a.m. My computer took 43 seconds to start up so I could log in. That means I need 43 seconds extra to prepare for my trial.
And let's be honest, the court has dealt with pro se defendants before. So I am sure there is a system in place, and she has a private investigator now that is funded. Couldn't he find the people she wants for the witness list? I mean, isn't that the reason you would have a private investigator, to help you maybe facilitate finding people? I mean, call me crazy. I'm just spitballing here, but
again,
yeah.
Who is he going to look for? I know she will say, go find me an expert who will claim if you say not intentional, there's the 26th Amendment to the U.S. Constitution that makes it legal to put people in suitcases. And he will look at her and say, did they get the strong pruno this week? and she will be, Your Honor, I can't, I won't drink. And this PI asked me if I had been in the pruno. I might have had a good day, but it was only one bottle. I don't drink. Please give me a new PI. Thank you
She's
so
like,
much,
please
Sebastian.
find the puzzle and painting so I can prove it was a good night.
Thank you so much, Sebastian Müller, for 20, count them, 20 gifted memberships. And they went to TD, Oracle Cat, Young Black Economist, Venus Victor, Kate Demasi, Kay Swan. Why does that look? Robin S58, Mother of Papillons. That's butterfly, Jamie in French. Emma TG, Heather Musher, Mary Murphy, Esprit Fleck, The Fluffy Cat, Marianne, Salty Dog 78, Lorraine O'Shaughnessy, it's a cousin of Ice Cube, Adelaide Lass, Lady Star, Peggy Otis. Thank you so much, Sebastian. And welcome to the Muffin Tops, all of you who hasn't been a Muffin Top. I see some repeat offenders in there. Welcome. You know the rules. No rules as long as you don't play nasty with people. But thank you so much, Sebastian. The YouTube's God are not helping me today. With what? Oh, Mo, are you a brand channel or are you a personal channel?
I don't know.
Oh, you'll.
What's the difference?
Can you get gifted memberships?
Yes.
Okay, then you're not a brand channel. Can you give away memberships?
I know there's a way to do it. I haven't figured out how to yet.
Hey, before I go, so glad you're back. Hope everything is looking just a little bit brighter. I won't say everything will be bright because you've been through a lot, but glad to see you here again. And I hope everything is going better. You don't have a branded channel. Well, I have a branded channel, so I can't get it. But the stupid thing is, I can't give. I think other channels can give away like 10 free memberships a month, and I don't get to do it because I'm a branded channel. Because my other channel had my name on it, so I didn't want to film stuff on that one. I didn't make it a branded channel, and I can't move it back because then I'll have to demonetize me and build it up again. Probably wouldn't be that hard with almost 12,000 subscribers, but still, it's a little annoying. Kelly Evans, reach out to Marissa or Josie, and they will send you a link. If you're a member, the link is in the membership section on the YouTube. But it's not a pay-to-play Discord, so if you want to be there, just reach out to one of the admins. I don't put the link out totally open because, as you've seen in the Kyrie case, a lot of trolls came a sniffing. So, yeah. Brighter now. You two look great. Thank you so much. Well, the subs will come out tomorrow. It's your lucky day for subs tomorrow.
And also because of the court era of sending.
Michelle, you of course you can get to 500 subscribers. That's it took me a year, but it's hard work. So yeah.
My information that you're referring to the incorrect address. Could you please provide me a copy of that also?
What is it that you're asked? The protocol, ma'am? That was what was most recently sent.
I don't know. Whatever it is, the last thing that I received from you in the court was the hand delivery of the order regarding
Sure.
USD.
I have a copy that Madam Clerk's already printed out of the protocol. We will have the deputy hand deliver that to you right after. Yeah, I did. Oh, I sent it to Anita. That's fine. Give me a second. I'll have Madam Clerk print that out for you right now, ma'am. So, understanding that as of right now, you do not have hard copies. You'll be provided digital copies. And to review all this evidence, ma'am, when in time do you feel comfortable in providing the court and the state the list of your witnesses and your exhibits that you may be seeking to introduce?
Sorry, I'm going to do something I don't normally do. Michelle says she'll never hit 500 subscribers. She has a channel about slow stitching, junk journals, and other creations I make from paper and fabric. It looks like she does a lot of videos about crafting stuff. She is at 483 subscribers.
Oh, we
If I
can
put
do
a-
this.
Oh, I put her name. I didn't put her link. Can we do a homie a favor? Just go over there and get her to 500. It's Mo. You would love stuff like this.
Oh, yeah, I need to craft. I need another crafting addiction. Like Mr. Mo needs a Samsonite, so I won't tell him.
But you can do a lot of men's junk journal event.
Ooh,
Oh, she writes journals about. I didn't know that one. I should look into that video.
wait, journals
Men's
about
junk.
men's junk, or
Yeah, it's she Michelle. Is it fantasy men's junk or is? I have to watch that video. I think I have to
I
do
was
that
about to
when,
say, do we have the
we're done.
French pole vaulter in there on the front? I don't know. That story will never not be funny to me because I'm 12.
Yeah, it's oh, you got to 500.
Awesome.
Don't tell us you didn't make to 500. 508. Congratulations.
Woohoo.
This is what YouTube should be about: sharing, caring, and
Yes,
helping people out.
absolutely.
So now you just have to get those watch hours in, and then you can be monetized, and you can teach Mo a new addiction. And Mr. Mo
Yeah.
will hunt you down.
Probably.
JRN, in no story he ever tells would his knee have hit it before. It'll
Yeah,
be
no.
his junk all the way.
Absolutely. I mean, if I were a dude, I'd say that.
512. Then you have a few to spare. Thank you,
Yeah.
Helen from Holland. Congratulations. Yeah, that's what YouTube should be. Yeah. French Paul, was he French?
Yeah, and there was some scuttlebutt about the baguettes of the French divers as well. I have an encyclopedic knowledge of baguettes.
Deline, have a great night. You were a subscriber. Mo cracks you up. Well, this one was for Michelle's Mixed Media Madness. So let's spread some love, help people grow a bit.
Yeah.
I'm going to go with to each one because I just explained also please that I do not have access to a regular phone. I need to locate anyone. I need to do research. I don't know if I have internet access to anyone. I don't have a phone book. There's no way that I know how to do any of this without essentials and fundamental equipment in order for me to be able to provide you with an answer. I cannot promise anything because I do not know how I will be able to do any of that at this moment. I would like you to propose your understanding of a meeting that I would like to have with the captain so I can see if I can have access to a regular phone, if I can have access to an internet. Right now I have a tablet that is used for text messaging and movies and the law library that I utilize. I don't have access to the phone. I don't have access to the internet.
You can certainly have those conversations with the jail representatives. But ma'am, we were on notice today to address those deadlines, and I cannot set a to be determined deadline at this time. I understand that there's been some delays with regard to discovery. As I told you at the last hearing, we're moving as expeditiously as possible to get you that, and it took some time for that process to be created. That process is going to start today. Mr. Lane's here. Representative from the Orange County Jail will be here. That handoff will take place. You'll have access to that laptop with all the information today.
If the defendant's not going to make a suggestion, make a state.
Sure.
My suggestion would be to give her 14 days after the points that the specific evidence identified by the state to be used at trials provided to her. So, for example, the physical evidence, which we plan on giving her the list of those physical items well in advance of September 3rd. That will just be the date that she can actually see them. But my suggestion for those physical evidence items would be September 17th, and then 14 or 15 days after whichever day we get the specific list of digital evidence items to her. Would be our suggestion.
Ma'am, are you amenable to that? 14 days after you've had the opportunity to review the digital evidence and 14 days after you've reviewed the physical evidence to provide your exhibit lists?
I don't feel comfortable with any of it. I don't have the same opportunities as the state or any attorneys prior. So I feel that you all are pressuring me and forcing me into these things which I may not be able to meet or exceed.
Can I add that obviously either side, if there's good cause for why a deadline wasn't met, if something comes up, then we're not prohibited either side from complying with the rules of discovery afterwards. But there would just need to be a cause shown.
Do you understand that, ma'am?
I do.
That I'm setting these dates for now, and if either party can establish good cause why these dates should be moved.
Yes, and that is why I'm trying to make everyone aware prior to all of this to understand my circumstances by being incarcerated and not having access to them, not having access to the internet, and not having access to any more other, like I said, basics, fundamental basics, which is why I'm making you all aware now, so you are aware that when the time comes, should it, why for good cause, I'm seeing my good cause now is not there or additional at that time.
Ma'am, as of right now, the court is inclined to agree with the state's suggestion that 14 days after viewing the digital evidence, which will take place no later than September 3rd, sounds like it'll take place way in advance of that, you are to provide in writing your list of exhibits that you want to attempt to move into evidence. 14 days after viewing the physical evidence on September 3rd, you are to provide in writing.
Evidence so far: physical evidence, a suitcase, a dead body, digital evidence, 2 videos, 911 call, body cam from first responder, body cam from the detectives, and video from her interrogation. That's the evidence that it's 2 boxes of evidence. Del Brooks had more. Let's just say that.
True.
Yeah.
A list of any exhibits that may be physical that you intend to enter into evidence. Those dates can be extended.
Yes. All of these things help all the small channels. And just, I hate to say the YouTube lines because I hate it when YouTubers say it, but touching the button and hitting it makes everyone stay a little better, especially when you're just around that mark of, oh, am I going to make it? Am I can I make this grow to
yeah.
anything? You love that. Write a comment. Just say, just like you do to me, say I'm fat. I don't know why people feel the need to tell me what I know, but some people do that. And I have to unsub because you had that, you said something about a woman's clothes. Any comment helps.
Yes.
But if you see a small channel that you like, maybe also if you know a bigger channel, recommend them, and maybe they can do some work together. And because I
Yeah.
know branching out is, we sit here in our little isolated pockets 8 hours a day,
Yeah.
and you know all the cool people. We are just talking heads.
Well, yeah, and I will say that you know, wearing wigs, being goofy on the internet, no problem. But, you know, reaching out to other creators, actually having to people, that is still something that I'm learning to do. So, you know, don't you miss 100% of the shots you don't take, you know, try. It took me like a lot of self-talk and Baker helping me, but I start sending out, you know, hey, you want to talk about this, you want to talk about that. And it does get easier after your first mental breakdown one.
Yeah. And why do people call me fat? Because they don't really have any arguments. Then it's easy to say, well, you're fat. Well, I am. It's not like, oh my God, I have no mirrors in my house and my pants just keeps getting smaller. I know it's the little gnomes that live in my washing machine. No, I know it's not the calorie trolls, because calories are the things that makes your clothes smaller.
True.
That's just science.
It's them air calories. They get you every time.
Yeah. What she doesn't realize is by messing the judge around, he's the one that ultimately sentenced her. So instead of haranguing him, perhaps be a little nicer. Well, if he did his job and understood her. The problem is she has the Karen mindset.
Yeah.
For a good cause that may be shown. State, would you like the opportunity to review those exhibits similar to an evidence viewing that we're having with Ms. Boone reviewing state's exhibits? Would you like a similar opportunity to review any of her exhibits?
If the defense has any physical evidence to place in evidence, I can make those arrangements with
Okay, all right. I will set a deadline for.
And Ronnie is a moderator for the lovely Ada, who does a lot of sign language interpretation of cases, which I think is a niche mark and that people should know more about it.
Yeah, and you know, making better closed captions so people that have a harder time hearing, because court TV's captions are from whence all shenanigans flow. But I love that we have so many different people that can give different perspectives and bring people that maybe wouldn't normally have the opportunity to join this community in, because she's giving those, you know, she's making it accessible to them, and I think that's awesome.
For the review of September 26th.
Is the review that you're speaking of for my exhibit and witness list?
That is correct. I would also propose a similar date of September 17th for any of the witness lists for the defense. And Mr. J, would you be in a position by the 1st of September to provide any witness lists for the state?
She should have a witness list in the discovery that's being provided. As far as the order and the list of witnesses that we're going to call a trial, we will be getting that ahead of 9/3.
Okay, all right. So the deadline for the state's production of the witness list will be September 3, no later than, and September 17th for Ms. Boone. Ma'am, similar to the objections to any discovery, that'll have to be in writing as to who it is that you may be calling as a defense witness. You'll have to provide that to the court in writing by September 17th.
Yes. And if I may ask, please, what you're typing, is that for an order or for today's proceeding?
It is for an order, which you will be given a copy of. It may not be able to be hand delivered to you, ma'am, because I'm going to have to move some stuff around based on my scratch notes here, but at a minimum, it will be mailed to your proper address. Due to that clerical error, that will not be an issue. Okay, I think that addresses all the issues with regard to repercussion and hearings on any objections. Anything else from the state that you believe we need to address from a scheduling concept?
we're good with scheduling concepts. Thank you.
Thank you. Ma'am, do you have any questions with regard to the scheduling concepts or deadlines that we've addressed this morning?
Other than what I had said, no,
Okay. Bruce, can you see if Mr. Sergeant Casey's here? He is here. All right, very good. Sir, could you come on up, please? Madam Clerk's going to go ahead and swear you in.
I'll try to boost it again. It distorts the
You
sound.
stay at the podium, sir. Yeah, just the podium, Sergeant.
Oh, sorry.
If you could raise your right hand, Madam Clerk's going to go ahead and swear you in.
He is from the JOA. He's there to help out, facilitate some of the stuff, providing her with a pro se package, and that's the most he have done. JAC, no, JOA, right?
I thought it was the JAC. I don't know. The names change slightly every state you're in, so it's hard to remember.
Yeah. And Lorelei, I won't make that because I was told I was being racist because I didn't make an East Asian accent. So I won't be fat, broken baker.
Oh,
No, that would be Jack, JAG, right?
yeah, but I thought that was for the military.
Yeah, that's what he said. JAC is military. And I said, no, that's JAG.
Dweez, I actually got that reference. Mr. Mo made me watch Dune.
Oh, I didn't. That was so boring. That's another one of my hot takes I can't say because it's the greatest movie ever. The first half hour is people standing in a room.
Yeah,
Sir,
and
can you state your name?
weird guy that's
Yeah.
naked. Why? Why did we have to see that? I want to sue for that.
Judge Advocate General. Yeah. These are the ladies and gentlemen of the Judge Advocate General. I love that show. She was such a hottie, the one with the short hair.
Name for the record.
Sergeant Casey.
And what's your position at the Orange County Jail?
Sergeant,
And what are your duties and responsibilities, sir?
I'm over transportation, downtown.
And no, as I always say, I see all of you as polka dots. It's just it was because I did my very accurate Southern drawl accent once, and someone said, "Hey, would you make make an Asian accent?" I said, "No, because this is a case in Louisiana or something, so it wouldn't really fit." Yeah, well, it's because you're racist. Oh, okay.
Huh? Have they heard your Scottish accent? Because that's a crime against the Scots.
Nay, me bonny lass, me Scottish accent is accurate.
Okay, that was actually pretty accurate. Sometimes it goes into French for some reason.
No, Nigerian is normally where I end up.
True.
We're holding university courts, medical security, and the juvenile assessment center.
Okay. Are you aware of the protocol that Captain DiGiovanni created with regard to Ms. Boone's use of the laptop?
I am.
Okay, all right. Have you had the opportunity to review that protocol?
I have.
Okay. Mr. Lane, can you come on up here, please, sir? Sir, can you raise your right hand now? I'm going to swear you in.
Yeah, betcha.
All right, sir, good morning. Could you state your name for the record for me?
Billy Lane,
And what's your affiliation with Prison Break Investigations?
I'm the owner and chief investigator.
All right, sir, last time I saw you, I had tasked you with digitizing 2 bankers' boxes of information, and you said that you would endeavor to accomplish that task by today, understanding that you were out of town for your son's wedding. I hope you had a great time. Were you able to fulfill that task, sir?
Yes, sir.
Okay. How many jump drives or drives do you have?
Of the digitized information, there's one of those, this drive here is a copy of all digital discovery that I have in my possession from Boone for the court's needs if they wish to facilitate that through the, it'd be easier to facilitate it now through the jail than me trying to bring it in myself.
That's exactly my thought. So you've shown me, sir, a small thumb-sized USB jump drive. That USB jump drive is the information that was contained in the two baggage boxes, correct? And the other jump drive that was the larger of the two, that jump drive is any digital information that you made had previously by virtue of being the investigator. Okay, all right, the record's going to reflect that information is going to be hand-delivered by Mr. Lane to Sergeant Casey. So Sergeant Casey, if you please take custody of those two thumb drives. And I'm going to ask you, sir, to comply with the terms of the protocol to have those added to the laptop and be available for Ms. Boone's use today once she's returned to the Orange County Jail. Do you have any questions for Mr. Casey? Okay, sir, thank you very much. If you can proceed with that task, I appreciate you. Thank you. Mr. Lane, you took custody with you, sir, as well. Well, before you leave, Sergeant Casey, state, do you have any questions for him? All right, ma'am, do you have any questions for Sergeant Casey regarding his compliance with the protocols provided to be by the captain of the jail?
Mr. Casey, could you please make note to Captain Giovanni that if she has time at some point, as soon as possible, please sit down with me for about an hour to go over quite a few things that I need to have resolved. Please, in regards to the laptop. Thank you.
Thank you very much, sir. Mr. Lane, when we were last here, you also had two baggage boxes. Did you bring those back with you, sir? Okay, could you bring those back up?
Look, he had 8 pieces of cake at his son's wedding. I've been there. Cake is good. The jacket just didn't expand.
I do see it looks like the original exhibit tags are still on the top of those. Mr. Lane, did you complete and copy everything that was in both of those boxes? Okay, I'm going to have Madam Clerk take possession of what was pre-marked as A and B for the purposes of the June 28th hearing, and we'll hold those into evidence. Do you have any questions, Mr. J, for the investigator with regard to his task? All right, ma'am, do you have any questions with regard to your investigator regarding his completion of the digitization process?
The final question is, Mr. Ryan, do you know when you would be coming to meet with the Abigail?
This would be my intent to try to get out at the end of the week.
I don't feel comfortable signing your invoice. I think Ms. Boone would have to sign it. Okay. Hand it to the deputy. Deputy will have her sign it, and then you can take it. Mr. Lake, is that acceptable, sir? Counselor, you're muted.
Yeah, that would be acceptable. Yeah, Mr. Lane, and in light of this, maybe it might be more appropriate for the court to go up to 10,000 for the investigative. It sounds like you've already done a lot of work. So it might make more sense instead of having to come back later.
Would that change the original, the 5,500, or just we would increasing 5,000 to 10,000?
5,000 to 10,000, I think would make sense, Your Honor, just because it sounds like that we may, based on what's already been done, Mr. Lane may have more to say about that, but based on what he's already done, I suspect he probably used a large chunk of that 5,000 just doing this one task.
One thing about that, Your Honor.
Yes, sir.
In lieu of having to come back and file another motion, is if JAC would agree to travel expenses out of county. If not, I can get that in some type of form of writing and get it to you or to JAC.
Mr. Lake?
No, we have no problem with the court authorizing, say, $1,000 for travel expenses as well.
All right, fine. So we'll increase it from 5,000 to 10,000 for investigative costs, and for travel-related expenses, 500 to 1,000. Mr. Lake, are you going to need a word for the court file with regard to those?
We would, Your Honor.
Okay, could you submit that?
Yes, Your Honor, we will have the order submitted.
All right, very good. Just send it to Ms. Berry, so I believe you have her contact information.
Yes, Your Honor.
All right, very good. Thanks, sir. Oh, Mr. Lake, thank you so much, sir. All right. Yes, ma'am.
What is his name?
That's Christian Lake. He is an attorney associated with the JAC, the Judicial Administrative Commission, regarding costs for indigent defendants.
And
All right,
thank
state
you
from a
for the
scheduling
report.
perspective or
Real world, but we have to deal with it sometimes. I have a mountain of laundry that is probably evolving into the blob right now, but folding stinks.
the protocol, which I know I thought that it was fine. I'm sure you had the opportunity to review it. Anything else we need to address from that?
We're good on scheduling, Your Honor.
Okay, thank you. Ma'am, anything else we need to address regarding scheduling or the protocol other than what you've already addressed this morning?
Will my investigator be present at anything for and with me?
I can't speak to for or anything, but based on what we discussed today, your investigator will be there for the digital review, which will take place no later than September 3rd.
Okay, yes, I would like to have some kind of witness.
He will be there. He will be there. Mr. J is going to be recording the conversation as he identified previously. And ma'am, you made reference to some motions that you may have brought with you this morning. All right, if you could hand those to the deputy. Also, to the extent that the deputy has not already done so, I printed out a copy of the July 24th, 2024 protocol regarding your use of the laptop at the jail. And I'm going to ask the court deputy to please hand deliver a copy of that to you. It was mailed to you. It was read to you at the last hearing, but now you have a physical copy of it, ma'am, to the extent one was not already provided to you.
Oh, yes, I have not received this yet.
Okay.
And then also there's another printout that she was going to provide me with, which I believe was a memorandum for today's date.
I haven't, is she being who, the captain?
No, I'm not sure the name.
Oh, Madam Clerk, no, the only thing she's printed out for you right now, ma'am, is that protocol. I'm going to be finalizing the order. And like I said, I may be able to finish it before we're done with the hearing, and I'll hand deliver it to you. If I cannot, it'll be mailed to you.
Yes, I understand. It was regards to another document proposing the dates for today's hearing. And I guess it's some kind of notice. That's what please that she was going to print out to give to me before I had that.
Okay. Here.
I did not receive that, nor did I receive this protocol list.
As to everything that's been discussed. Can you print it? It should be in the file. All right, let me take a moment to review your motions. Give me a moment here.
Thank you.
Ma'am, with regard to one of your motions, the motion for defendant's immediate address correction, as identified earlier, there was a clerical error using the general PO box as opposed to legal mail. That's been remedied. So I'm going to go ahead and grant that motion as that's already been remedied, but I don't have a problem granting your motion for the correct address for any legal mail. Mr. J, if you want to approach sir to review the hand-delivered motions, it is the motions for defendant's reasonable freedom and movement by allowing her to be unshackled, unhandcuffed, to function equally and comfortably while utilizing the courtroom. Second motion is the motion for defendant to lawfully receive, review, utilize the original hard copy discovery, parentheses, 2 boxes, (A, B, parentheses, submitted to the court by former attorney, parentheses, S, and parentheses, on June 28, 2024, for preparation of trial in her criminal case. Just review those, counselor. Just let me know when you're ready to address them.
Your Honor, in regards to the first motion, we need to notice the sheriff's office, who is in charge of courtroom security. So we're not able to address that today unless they're allowed. I don't know if you're able to contact the person that's in charge of that today. Otherwise, we would need to separate date for that motion. Okay. As far as the second motion, it's completely up to the defendant. We have no standing to say anything about it. If she wants to have her documentary discovery in hard copy form, that's between whoever and whoever, but not the state of Florida.
Okay, I appreciate that, sir. Ma'am, with regard to your request for discovery, or the hard copy discovery, you've advised me multiple times seeking to use a laptop. I've written correspondence from you asking for a laptop. That laptop is being provided. At the last hearing, you advised that you wanted hard copies. You've also advised me that you live in a female dormitory, you have limited to no privacy, and you have nowhere to store anything. You have a small drawer to keep personal effects, and that's it. There's nowhere, in my understanding, in communications with the captain, to place this information. There's nowhere to house it. There's nowhere to store it. You do not have, by your own admission, any place to place it.
Is that your understanding now? Or are you asking me?
No, those are just statements that I know that are in the court file that you've made. You've written letters requesting a laptop that's been provided to you. You have written letters, ma'am, specifically asking for a laptop.
Do you know what the date of that is?
Without me going through all the correspondence. But when we have our hearing on the issue of the your motion for freedom of movement, well, I'll notice the sheriff. We'll try to set that up for this week so that it can be done expeditiously.
Okay.
We can address that at that time. But the jail has advised me they have no place to store this information, these hard copies. You've advised me you have no privacy and nowhere to place them. So I'm not saying no, but I don't know how I can facilitate this for you. You do not have a place to store it. The jail does not have a place to store it.
We have an entire property department for all of the inmates in the entire compound. I've been given permission also by sergeants.
Who?
Corporal Ward, Sergeant Dunn, Sergeant Jesus. Have the understanding that I have been forced to represent myself as pro se and have temporarily given me a property bag where I can store additional case documents at my bunk. Help me understand, please, for future reference, so I know how to approach. By my statements that I made to you, questions were not asked in order for you to come to the conclusion that you are coming to that I did not want my hard copy. I was never formally asked by you to see if I wanted my hard copy discovery. I would believe it was the court's understanding, the judge's understanding that it should automatically be allowed to give to me. My understanding and trying to explain to you also, so you have an understanding, is my limited restricted access to the laptop is from 8 to 4. I, with 62 days left in order to defend myself in preparation for trial, would like to close that laptop at 4 p.m. and then pick up the discovery hard copy in the 2 boxes that I have. I haven't spoken to the captain yet. I just now received the protocol for the laptop. I know that you had mentioned it to me the last time that we met with one another. So I'm confused how everyone is confused by me coming to the court with solutions and ideas and suggestions, but are being misinterpreted and misconstrued by my letters from my attorneys you're coming to the wrong conclusion.
I'm not coming to any conclusion. The process was created, and I'm just reciting what you've said to me. That's all I'm doing. You've told me you have limited space. You've told me that you have no privacy, and that you have a small drawer for personal effects. This is the first time I've heard anything about you having a locker or some kind of bag, a property bag, that you now have access to. That wasn't addressed at our last hearing. This is the first time I'm hearing about it. So I'm not drawing any improper conclusions, as I identified for you with the process. The jail created this process. It was something that they put together. And as I told you, we worked diligently to move forward to get with the jail to have this done. There's no nefariousness here. There's no undermining. There's nothing along those lines. I want you to have this information. And as I addressed at the last hearing, I could not copy it. I can't look at it. I can't look at what's in those 2 bankers' boxes. Ms. Barrios cannot. No one associated with my office can look at it. We had to use your investigator to do that. And what the jail has advised me is that they were not in a position to take both those bankers' boxes because of space and potential hazards. Now, if something has changed and the captain advises me that you can have those documents, I don't have a problem with you having them. But what I've been advised, as identified in that protocol, is to how and when you can have access to the information. And unfortunately, it wasn't in physical form. It was in digital form. And that was the process that the jail created. They are aware it's 2 bankers' boxes. They're aware of what the information is. Everything has been out in the open to address your concerns and how to facilitate getting this information to you. No one's withholding anything. No one's trying to hide the ball.
My opinion differs. I was never asked anything. Just like my letters to you prior to you forwarding my right to counsel, I was never asked anything in order for you to have a better understanding.
No, I'm not going to revisit that.
I am not, you never asked me in regards to the hard copy.
Hang on. Yes.
How quickly can we have an evidentiary hearing with Captain or whoever we?
My understanding is she's on vacation this week. So, which is why Sergeant Casey was here, because Captain DiGiovanni is on vacation. And I cannot recall off the top of my head when she said to return. She said to return on the 12th.
So, if the document, what would be the process? Because it's marked, tagged, and in evidence, so there would need to be a motion to get it released from evidence. I would entertain an or tennis motion to have it released from evidence. The concern, as Mr. J, this is the first time I had the opportunity to discuss this case with you. I know I've been dealing with Mr. Cacciatore. We had a hearing, and I'm sure you're first on this, but let me just kind of bring you up to speed. We had a hearing in June, and at that point in time, I forfeited Ms. Boone's right to an attorney based on her conduct and alternatively a waiver. And I'm sure you've read it. Thereafter, the court endeavored to figure out how to get those 2 bankers' boxes that Ms. Cashman had provided to the court at that hearing in Ms. Boone's possession. It took time for the jail to come up with a policy and a procedure for that to happen. I was advised by the captain that they could not take custody or possession of those 2 bankers' boxes because of A, storage, and B, because of the hazard. Now, if the jail is in a position to revise that by virtue of Ms. Boone identifying a property bag or something that may be available for her use, I am 100% on board. If the jail says, yeah, we can facilitate and make that happen, her getting that information. I'm just traveling with what I've been provided, and the protocol that was provided to me that's been filed in the court file was not inclusive of providing her hard copies. Actually, I'm just trying to find a solution. So
Same.
If she moves or tennis to release those 2 exhibits to her investigator, then perhaps he can try and get them released to her. And if he cannot, then it sounds like on the 12th, we can revisit this when it happens.
I think I don't know if she returns on the 12th or that's when her vacation ends. But it's a Monday, so I'm assuming she'll be back, but I don't want to make any affirmative statements on that. I don't have a problem. Mr. Lane's had this discovery. I don't have a problem with him taking custody of it again. And if he's able to deliver it to the jail and they allow it to be released to Ms. Boone, I don't have a problem with that. I have no problem with it. I'm just traveling on what the jail has advised the court in the creation of this process.
So if she wants to ori tennis between oral motion, move to release those 2 exhibits, the state has no objection. And it sounds like if Mr. Lane can't get them to her, we'll be able to revisit this in the near future. Yes, just so that she's advised. So I won't ask her, but perhaps the court can.
Sure. Ma'am, the state has recommended a position for in an attempt to get you these hard copies. Is that something that you would like the court to, would you like to follow with the state's suggestion and ask of that of the court orally this morning?
I'm not understanding what it is that he's trying to do. They actually proposed that the hard copy goes to Mr. Lane, and they want to have permission by the captain and whoever to release them to me.
Granted.
Sorry, I was on my phone talking to my daughter, so I don't know which issue. I will get Marissa to call courthouse right now.
The audio is terrible. They don't mic Sarah up, so it is a little bit harder to understand her. I will say that this audio is much better than the original audio. This audio has been boosted, so hopefully in subsequent hearings, Sarah did put a motion in to be able to move freely around the courtroom. Maybe they will allow her to sit at the defendant's table and be on mic if she's able to argue that.
Yeah. I can't do anything because if I have boosted and Shizzy boosted it already, so we can't boost it more, sadly. But it's done in 14 minutes.
Okay, Mr. Lane, thank you for staying, sir. I appreciate you. If you could come back up here, sir, and take custody of both of those bankers boxes. I will have Ms. Barrios coordinate a hearing for the 13th at 8:45. We cannot do the 13th because it's pre-trial. You're correct. We will have a hearing on August 14th, if necessary, on Wednesday, August 14th at 1:30, if we need to address the jail's position in taking hard copies if Mr. Lane's unable to have it delivered. Mr. Lane, you advised earlier when Ms. Boone had inquired of you as to when you might be able to go visit her. You said the end of this week or by next week. If when you go to visit her by the end of this week or next week, bring that with you and see if the jail would be in a position to take it. If they are, I'm going to ask you to file a similar notice, sir, that that information was provided to the jail on what date and to whom. Okay. All right. Thank you.
Your Honor?
Yes, ma'am.
What would the hearing be for on the 14th then, for the jail taking?
The hearing on the 14th, ma'am, would be if Mr. Lane is unable to have the jail take physical custody of those two boxes for your review outside of the laptop. We would have a hearing to address what, if any, protocols the jail may be able to utilize in you having those documents. It may not be necessary. We're going to go ahead and set it if we need it. If we don't need it, we will not have a hearing.
Thank you. And so there will not be needing to be made an updated evidence control sheet right now. It is impossible to make.
As of right now, the court minutes are going to reflect that what was pre-marked as A and B from the June 28th hearing is being provided to Mr. Lane. Okay. With regard to your reasonable freedom motion, I'm going to set that for this Friday. Is the state available at 8:45 on Friday?
No, it was at 8:30.
That is the 9th, ma'am.
And Tam Jules, we are happy you found us too. We tried to make it inclusive, nice, and make it a little
Available, Your Honor.
Okay. Ms. Barrios will coordinate with a representative from the Orange County Jail to address the reasonable freedom motion. Ma'am, I'm going to hand file both of these motions with Madam Clerk, okay? All right. Is there anything else we need to address this morning, State? Anything else we need to address, Ms. Boone?
Please bear with me.
Why do you keep asking her?
Was the conclusion for the sensitive issues of having the media incorporated in the courtroom?
I need to research that matter a little bit further before I can make an order that would prohibit media access.
So what's your deadline, maybe, or estimated?
It'll be well before the 3rd. That's deadline is set for September 3rd at 9 a.m. when we'll have that viewing. I will endeavor to get that done as quickly as possible. Ma'am, you also had asked for a list of the persons that Captain DiGiovanni had provided, the names of the persons at the jail regarding the laptop protocol is Captain Giovanni, Donald Casey, who was here this morning, Stephanie DeJesus, Sonia Robinson, Courtney Battle, and Malik Muhammad.
Thank you for that. We should be able to provide you with a hard copy.
I will put that in the order that'll be mailed to you, ma'am. Okay.
If I may, I don't know if I'm allowed to address the state directly.
You can represent yourself, absolutely.
How would I go about getting a copy of my phone or utilizing my phone? Is that something that can be brought to the courtroom? And during the evidence, should the physical evidence that I might be able to utilize that?
Why isn't there a copy of my phone? Can I get the physical evidence? So she wants her phone back?
Here's what Sarah does in real life. She can notice how she continues going back to things he has already explained to her. This is what she does in real life to her partners. You will try to move on to something and she just wears you down until you're like, yes, Sarah, you were completely right. Can we please, can you please drop this if I agree with you? Because she's an emotional vampire and she will suck the life out of you.
Yeah. Yeah, and she, when you say, but we discussed this, I didn't feel like we reached a conclusion. Well, we did. No. She'll just keep going.
Yeah.
That's...
So my understanding is there was an imaging done on your phone with software called Cellrite, and that is part of the digital discovery that's been provided to you. If you are talking about the physical device being re-examined by your own expert, then you would need to find and retain your own expert to do that without giving you legal advice or suggesting that he's the person you hire. I know that defense attorneys in this area hire somebody named Richard Connor, Connor, and then that will be between you and JAC about and him, whether or not he wishes to work for you and at what rate, so on and so forth. And then that examination would be done by him, with us being present if we want to be present.
Yes, I have reviewed, I believe, 2 or 3 different thumb drives were given to me at one point, where I researched all of them, essentially also include the Mr. Lane, and it is nothing of use. It's primarily cookies and history and so forth. So that's why I don't understand who it is, a legal expert that can give me a mirror download of my entire phone in regards to videos and pictures and contacts. I could probably supply a witness list for the mayor if I were to have accessibility to my phone in regards to my contacts. That's why I didn't know if it would be allowed to have my phone visible here in presence of everyone, including law enforcement, to be able to look at my phone and go through it and see what I can extract myself while here in the courtroom before trying to figure out how to locate and contact an expert to download all of that to receive.
So all that information should have been downloaded, and I'm not sure.
Honey Boo Boo, you won't get your phone. It's evidence in a case. Because then you can delete stuff on your phone. And let me tell you about this magical tool called Cellbrite. Us Karen Reed watchers are proficient in Cellbrite. It's really a bad forensic digital tool. No one uses it outside of Canton, where everyone used it. But it downloads everything. Every picture, every website you have been on, every connection you had dialed, text. And I know you said, I had 2 thumb drives and I went through all of it. I studied it. It was just cookies. No, you just didn't understand it.
Yeah, she probably got the Cellbrite record and she's like, but I thought I was going to get my phone. That's why she's really pissed. She's like, I just want my phone back. This whole trial has been a journey not without my phone.
And again, when you get those Cellbrite reports, we saw them in the Karen Reed case where it'll spell out date stuff. She has been looking at that and said, I don't understand any of this. This is mumbo jumbo. It doesn't make sense. It's actually not that hard to read when you first get the habit of it, because we use it in court all the time, except in the triangle where you need some British guy with his homemade program to show you that the program he sells doesn't work. Don't think about it. She just wants to scroll her contracts. No, she wants to delete her video.
Yeah, she's like, oh, it isn't here now. I guess it doesn't exist and I'm out.
Yeah, not intentionally deleted, but that's me gone. Bye.
Butterfingers.
Yeah, well, I guess I'm not either. Cookies would absolutely not go real well with my coffee right now. I still have some cookies from the other day. Yeah, she needs that guy to say, nope, never was on the phone. She never took the video, but it's still on the phone. Never been there. Well, at least she could pay for representation. Not good representation, but she had representation.
Yeah, though, whoever her optics woman was, and they're like, no, dress like Ava Braun. It's a great idea.
Yeah.
No, seriously, everyone will love you.
She probably said, oh, I watched this funny movie yesterday, Mel Brooks, The Producers. Way underrated movie. More people should watch it. And I really liked the outfits. I didn't study history, but it seemed like everyone was laughing. So let us put you in one of those snazzy uniforms.
She's like, I've always loved Hugo Boss.
Yeah.
Sure what has been provided to you, but we will be double checking that. Yeah, your contact information, all the videos and photographs, everything on your phone should have been downloaded. What you may have reviewed is just a PDF file called the timeline. There's additional data there, and we will make sure you have that. then when it comes time to our digital evidence deadline, which I hope to exceed well before 9/3, we will be identifying which portions of it is of your phone, if any, that we seek to introduce at trial. So it may be texts from December 2nd, 2019, whatever it is. We will identify those pages, we will identify those files, because obviously your entire phone, however many gigabytes it is not going to come into evidence. Like you said, so much of it would be not relevant.
Yes, thank you. So you all have already had access to my phone and have researched it fully?
We're not going to talk about our work product. I'm telling you what, based on my experience from other phone examinations is, all that information should be there. There's typically presented in two different fashions. One is a large PDF, typically hundreds of thousands of pages, depending on how much you use your phone every day. And then there's a separate big digital image file that is read with what's called a UFED reader. And then that is where you can go in and look at everything.
Yes, sir, thank you. I've not seen any of that.
We were going to make sure that that's there.
Now, just as clarification from a court perspective, is that something that would have been provided in discovery to prior counsels?
Yes.
Okay, then, ma'am, as Ms. Cashman identified, she had everything. It's already been digitized for you, and to the extent you're able to have the hard copies, it'll be provided to you. So you'll have access to all that information today when you return to the jail.
Yes, thank you. None of it was gone over in any way, shape, or form with Ms. Cashman or anybody. So this would be a milestone, an epic milestone for you to do that. So now, if I don't have what I need or I'm looking for, how do I go about? I know you all can come because of legal matters, but do I need to write a motion? I don't know what I need to do in order to finally get a copy near download of my phone. Is it going to be brought to you or physical? Or the other physical?
So again, that's going to be something that requires an expert. And then if you get a defense expert, the JSC pays for it, then we make arrangements to meet with that expert. That expert will have the opportunity to image your entire phone just as we did, and you all can work with that image. You're going to be.
Thank you, Rabbit, for 5 gifted memberships to LH, Terry Beetle, Chantes Inferno, Ellie Rose, Little Gambler, DK Cripple. Thank you so much, Rabbit.
If you don't already, on those thumb drives that Mr. Lane has, if you don't already have a full extraction and not just the PDF timeline of your phone, you're going to make sure that that is.
Okay. So that is not able to be included in the other physical evidence that you will provide.
No, what I'm saying is there's two different ways that I see phone extractions. One is the PDF, which is what I think you're referring to as the timeline of this communication, so on and so forth. And then there is the.
Because she is not listening to any of the answers they give her. She just sits there and say, but I'm right. I want my phone. I should get my phone. Why won't they give me my phone? And then his mouth is moving and she's in her head saying, but I was looking at all the paper and I was a 4.0 average in high school. And I know how to read a Cellbrite report. Oh, he stopped talking. I'll better ask something. But could I get can I just look at my phone in court? Oh, now he's talking again. Doesn't he understand? I really just want to understand because I need this in my defense. Oh, he stopped talking again. That's her problem. I think her it's kind of like me when we go a little long, I start to go on Twitter and argue with politicians or someone because my brain just needs to run away and hide. So I do that sometimes too.
Yes.
Yeah, and the good thing I like in this case, after hearing this hearing again today, they are really helping her out, but she doesn't understand it. They are giving her every opportunity to get the help they're not allowed to give her. Not legal advice, but I can recommend this guy to be your expert. But she's too thick in the head to understand anything.
Yeah.
Yeah, she's not doing the insanity plea. She's not Reginald. Why can't I remember his last name? The third. Just
Is
screaming.
it Reggie Jackson the third? I want to say
believe
Jackson, but I don't. Was that a sports ball player?
It sounds baseball.
Yeah.
I don't know.
There's so many pieces.
That is read with a UFED program, and all that should be provided to you. Hopefully your laptop can use it. It does take some specifications on the computer to open it. In fact, we're addressing those issues at our office with our own computers. And if it doesn't work, we will cross those bridges as we get there. And I've worked with Mr. Lane before. Just let him know. Mr. Lane knows how to find me. We will work this all out and get what you need.
Absolutely, yes. I am grateful for your information. Just to clarify, please, during the physical evidence of me doing that here in the courtroom, am I not able to physically open my phone and search through it?
No, because
Okay.
it needs to be in a Faraday box where radio signals don't come and go, because anytime you turn on your phone, it changes the contents of this phone.
Thank you
You're
very
welcome.
much.
Ma'am, do you have any other questions?
It was Ronnie O'Neill the third.
Okay, so
Oh,
everyone
okay.
is aware that.
So no
I
Jackson.
trying to talk to Catherine
And no Reginald.
and Campus. Okay. Your Honor,
Yes, ma'am.
I believe I am okay right now. You and I do not have a direct way of communication, and I didn't know. Another big hurdle is if the laptop has internet access where I don't know if emailing or messaging or whatever, however it is that you and I communicate. Rather than snail mail, I'm writing the letter. I don't know when I write a letter how soon you receive it, because sometimes it's days or weeks that it's uploaded to the clerk's website. Do you sort of general kind of thing of when you actually know something? Because you already have my address correction, but I don't believe updated.
It's been updated now.
Nothing on the clerk's website.
I can't speak to what's on the clerk's website. I know for the purposes of my records and getting information to you, that clerical error has been remedied.
Do you have any other suggestions? If I do not have internet, was my only possibility to correspond with the mail?
That's my understanding. And you asked when I receive things. I get it as soon as I get it from in the mailbox. So we check the mailbox every day. As soon as I get it, it doesn't go to the clerk, it goes directly to me. And I review it. As you saw with the motions that you made reference to at our last hearing, that you had 5 of them, we set those for hearing immediately. And I intend on continuing to try to do that to facilitate prompt resolution to any concerns or issues or motions that you may have.
Thank you. And if I do have internet access or I'm able to put on, if it's not already, am I able to correspond with you via email?
You cannot correspond with me directly, but you can have conversations with my judicial assistant to the extent that you do have access to internet. I'll make sure to include her email address and telephone number in the order setting the deadlines that we addressed this morning.
Thank you. And for any, I'm not sure specifically which JA, but as soon as something is scheduled, could you all please make sure that I'm included in the certificate of service or portal or whatever it is I might be attached to in order to receive those? Are they in here?
Notices have been set, ma'am. To the extent that there was a clerical issue, that's been remedied, but you have been copied on everything that's been filed with the court, including the JAC's response, the notice of the hearing that was set for today, and the notice of the filing of the protocol. With that, I will see you all this coming Friday at 8:45 to address the motion regarding reasonable freedom in movement. State, anything else? All right, we'll see you all Friday. Thank you very much.
Thank you very much.
We'll return Ms. Boone to the custody of the Orange County Jail.
I love that she said, "Thank you very much."
Yeah,
Because-
after she's like, I'm sorry, you mentally subnormal, barely human idiot. What seems to be the problem with my motions? Are you confused? I love her just general. She is just insufferable, and this is going to be terrible.
Just fix the goddamn audio. Because
Please.
her whiny "I'm a little girl" voice combined with the gain turned up to 11, it's really hard to listen to. But we're gonna have a hearing 8:45. If it's a live stream, I'll cover it. Yes, I know Karen Reed is in court at 2, so we'll take our precautions. I was looking at the Tillis case out of Nevada, but apparently that's been bumped to next week. So what I'm going to do tomorrow, I don't know. I know Mo is going to do her newsy news tomorrow.
Yeah, I do Newsy News at 8 a.m. in the morning. It's about an hour long. No real politics generally, no conflicts of any kind, just fun, weird, odd stories. A lot of them are court things. And then at night on Monday, Tuesdays, and Thursdays, I do nightly Newsy News for an hour at 7 p.m. And I try to do Newsy News nuggets in the morning and in the afternoon if I'm not doing a live stream. About 15 minutes of 3 stories that I think you'll like. If you do like political stuff, I am starting a new Politically Mo channel. My kiddos just got back in school, so I should be able to stay on track with those now. And then, yes, Eastern time, I am. And thank you all for compliments about my hair. I love it when I have a magical good hair day. It's a beautiful thing. So thank you. Baker's gone.
No, I was doing some homework behind the scene.
You were writing a letter to the judge. Fix the damn. He's cutting up magazines, getting his glue stick out.
I was just about to start. Put this next to the copier so the audio guy can see it. Fix the gain on the microphone. Your Honor, I have been denied my 4th, 7th, 25th, 28th, and 32nd judicial constitutional right as a pro se indigent litigant. Fix the audio. My fans around the world wants to hear the audio.
Oh, yeah, absolutely. They are it's so hard to hear, and she's garbled on some of the things.
I am Houdini. I'm a ninja. Yeah, she will write small notes and put it on each juror's seat every morning. No, that was the drunken demon voice. H is for Houdini. No, it's help wanted. Better audio is what I'm trying to work at, but I don't have the penmanship of Sarah Boone.
Well, her penmanship has DID. Some days she's really calm and it looks very nice. The other days I'm like, I think that's an O.
Am I consider covering the Alexei Traviso case, teen that had a baby in the bathroom and tried to hide it in the garbage can? I haven't seen when it started, but I've seen some stuff about it. I think she claims medical malpractice or something. I have been looking at it. I was also looking a little bit at the case Brandy just picked up, so I won't pick it up because we have a lot of shared customers, so no reason to fight over the same scraps. Not scraps, but all you lovely people. And Brandy, she's better than I am. Most people are. And so I will be looking. I have my brain trust rummaging through whatever could be a possible case. Well, I don't. Marissa is on the beach getting drunk. Jamie, who knows? She had Irish up there. She might have been abducted to Mexico. She didn't. I haven't seen her since Iris was there. And Josie have petitioned to have me removed from YouTube because I call her Josie. So my brain trust is on Sarah Boone levels right now. But I might. I'm looking for anything because I have Friday. I have something because I have the Karen Reed and this one probably won't be live. But even if I cover another case, we'll break for the Karen Reed stuff, and then we don't have anything until the last week of the month where the Richards trial is supposed to happen. So we'll do it that way. Game over.
Yes.
Is it game over for me or for whom? But thank you, Chances Inferno.
All right. So, what is the over under in how many letters the judge is going to get after today, because I'm guessing 18 motions and at least a 25-page letter.
Yeah, it's going to be horrendous. Your Honor, I was never told if I could have my phone. 45 times.
You are very rude and condescending, and I am an indigent, defenseless, forced pro se defendant, and you just don't understand my suffering.
How about a recap the TikTok psychic case? I'm too old to TikToky, so I don't know what that is. Is that the guy with the face thing?
Wasn't she the one that claimed she could explain who did the Moscow, Idaho unalivings? And she went basically on TikTok and accused, I think, a professor. I could be wrong. There's so many cases.
Put it in the take a look at on my Discord, and I'll take a look at it. Yeah, she alleged it was a professor. Okay. But put it in the take a look at, because I'll forget the second I go off screen. I'll just sit here and think. And then 5 hours later, Jamie will ask me, why aren't you streaming? Oh, sorry, I'll move now. Lots of old boomer people on TikTok. Yeah, which they shouldn't be. TikTok is brain cancer, because my daughters have it, and it's just swipe. It's kind of like Tinder. It's the YouTube Tinder. I don't like this. I'll go on. I go on. It's the same. Well, I don't do it, but some people can go on Tinder and find a date. But it's the same. It's empty. It's kind of like my diet. A lot of empty calories. See ya, Celestial.
Well, we all are retaining a couple Mike and Ikes somewhere. I feel like Sarah Boone. I just had to pay $100 for a graphing calculator. I feel like I should talk to a manager. Like, this is for math, and math sucks. Why should I have to pay for this?
Yeah. We are still here, and new video up on Michelle's Mixed Media Madness.
Ooh.
I prefer TikTok over YouTube for lives, but enjoy. Everyone is entitled to their own opinions. No, only my opinion matters. That's what I've learned.
As Sarah Boone has taught us, this is your world. Everyone else just lives in it.
Yeah, and I never. My daughter's housemate shows me videos of cars on TikTok, and I just sit there, and if I didn't hate him enough to begin with, it just adds to the, another thing on the list, another thing on the list, another thing on the list. So yeah.
Baker, it could be Skibbity Toilet. You could be forced to watch these demonic looking heads in toilets.
You super sticker wanted to say hit the like as well. Well, it said game over. So who needs a graphing calculator? Who doesn't? But
I have very smart girls, and they're going into calculus for reasons of, I don't know, self-loathing, that I haven't quite broken the generational curse. But they're like, we need graphing calculators. And I was like, awesome. Can't you use your phone? No, Indiana's made phones out of classroom now.
That's good. But dinner time, I'm gonna make myself a burger tonight. Talking about my fatness. Well, with a lot of salad. Mo will be doing her news later, and we'll be back mañana. Mañana. I don't know how to say the day after tomorrow in Spanish, but somewhere around that.
Tomorrow.
What exhibit are you referring to?
I'm going to make this 100, Your Honor.
All right.
100. Because it is 100% correct.
Checking your honor.
So you literally built a cannon Yeah, it's pretty awesome.
All right, I'm in love.
Go back. Please do that again. Oh, that was the cutest thing I've ever seen.
While I'm waiting for this, did you, whether it's true or not, believe that Mr. Randolph had slept with your wife?
I wouldn't care.
You wouldn't have cared?
No,
Did you believe he had slept with your wife?
no,
Did you believe he slept with your mother-in-law?
probably did. Everybody has.
So there.
Everybody has.